It's called the list.
May I permitted to mention?
It is not the mentioning date. Mention on Monday. Unless and until it is extremely urgent, that you cannot wait till Monday.
Matter not a compassionate appointment, Lordship. It's pending.
Mention on Monday.
Lordship.
It's very urgent matter.
Yes, what is the urgency?
Agency, my agency, your lordship, order dated 5th March 2025 has been violated. Your lordship directed the board to conclude the proceeding against the petitioners within 6 months. However,
You have filed a contempt petition.
contempt petition.
So mention on Monday. It's not an urgent matter that you cannot wait till Monday. Sorry. Yes.
Item number 1.
Item number 1, my lord, I am appearing on behalf of the petitioner, my lord.
I am for the state. I am.
My lord, I have applied for
Yes, yes, yes.
my lord. Kindly come to the page number 12, my lord. I am applied for West Bengal Police for the constable post of 2024, my lord. My lord, this is my application form, my lord. That application form has been rejected, and I am not getting the.
So why you have not moved the tribunal?
As because, my lord, the tribunal is not functioning. Bench is not there, my lord. During the mentioning, I have told
No
this.
bench is there in tribunal.
But I don't have any idea if there is any bench or not.
But others are not coming.
My lord, this is a situation.
In this
my lord.
matter, tribunal is the main jurisdiction
Yes.
authority. They have to.
No, my lord,
go
I
for tribunal
have checked,
first.
my lord.
There are so
Bench
many
is not
orders.
there, my lord.
Bench is not available.
Bench is not available. Only the registered bench is available, my lord. I have checked the list, my lord. Check the list, my lord. The problem is that, my
Sir, let me ascertain.
Huh?
Tomorrow under the heading urgent motion. Same heading. Next matter.
affidavit service may be kept on record.
No, nothing. Come back. Let me ascertain.
Well, right.
Item number 2.
May I, my lord, download the current list and show it to lordship, my lord, that the bench is not available.
Same heading it will appear tomorrow. এই শোনো তো একবার রেজিস্টার অ্যাডমিনিস্ট্রেশন কে ডেকে পাঠাও।
Malat, what happened in this case, Malat, here, the candidature of the petitioner has been rejected on the ground of shortfall of height. The petitioner crossed the hurdle of computer-based examination. Thereafter, he called for the PST and PET. PET has been done. He passed out. PST in PST stage. PST board, Malat, Physical Standard Test Board. Major
Constable GT.
Constable GT.
Where?
Malat, this year.
Where?
Malat,
In which organization?
Malat, it is conducted by the SSC, nodal agency, CRPF, including CRPF, BSF, CISF, Assam Rifles, and SSB.
Yes.
Malat, my candidature has been rejected by the PST board, page 19. Page 19, the measurement of the height has been measured 169.4. And the page 18,
Page 19.
page 19, 19. Malat, right, left hand side, clause 8, height. In the box, first box.
Page 19 is clause 8 is your candidature for recruitment rejected due to non-qualified in PST.
PST, height, my lord, 169.4. Thereafter, I preferred appeal as per the employment notification. That the appellate authority's order is page 18. Page 18, the height has been measured as 169.4 and chest 80.
169.4.
Four.
Page 18.
Page 18, appellate authority's order.
Yes, page 18. Where is the height?
Yes,
60.
we measure the 69.4.
169.4. Yes.
69.4.
This test is
Chest is within the permissible limit.
and after
And
measurement
weight-
height and chest 169 for yes.
Yes, my lord, the interesting part is here is, my lord, here the weight has been gained on the same date. Weight has been gained about 2 kgs. My lord, kindly have a look page
But if it is
19.
169.4, it will not be rounded up to next higher digit. It is up to 169.5. Yes.
My prayer is that
Wait.
my prayer is that, my lord, the measurement has not properly measured as because the petitioner in earlier selection process for 2024, I know you lost his views.
Harun
My lord,
Miaz
I am
matter, sir.
only,
Harun
yes, yes, I know. That matter also I
No.
have here. My lord, page 22.
No, don't
And-
waste court's time. Sorry.
My lord, one point I shall. my lord,
You have no point at all.
Thereafter, I know you lost his views, but I will not waste you the valuable time of the losses. My lord, page 19, right hand side column, it indicate the weight.
নামটা হলো মৃন্ময়
Your losses also
possibly
passed.
মৃন্ময় মন্ডল my lord মৃন্ময় মন্ডল
Yes, your losses
right.
also passed an order in my Mondol case that following that Harun. My lord, my lord, page 19 once, my lord, page 19, right hand side column weight.
How does it matter weight?
My lord,
If your height does not come within the parameter,
why I am submitting that? My lord,
sure.
there is a knob.
Time is being consumed. Yes. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph.
এটাতে কি
Female candidate below 150.5.
আমি একটু সিমিলার অর্ডার তুমি দেখে দিচ্ছি
156.5 তো বেড়ে যাবে
150 below লিখেছি না below 150.
ও আচ্ছা এর অ্যাকচুয়ালি এটা কই এর এটা কই ঠিক আছে দেখছি
লেখা আছে পেজ নাম্বার সব সামনে এই যে পেজ নাম্বার সব সামনে
ইমেলের কত 157
হ্যাঁ 157 না 150 রাউন্ডিং অফ যদি করেন 5 পয়েন্ট কমিয়ে দেন তাহলে 156.5 এ অ্যালাউ হয়ে যাবে ও তো তার নিচে আছে
আরেকটা আছে
এটাই তো
তিনটে ছিল তো।
রাজেশ কুমার পণ্ডিত বিল করার জন্য
এসো এই একটা অর্ডার বার করে রাখো তো আবার লাগবে WPA 22571 of 2025 এসো
শুধু এটা চেঞ্জ হবে তাই তো
এই রাইট গুলো হচ্ছে সব সমস্ত থাকবে আর
এটা
এটা হিজ হয়ে যাবে
2-3
জাজমেন্ট ফর্মে
3 আর এটা 13
এখানে দেখে নেবে হি ওয়াজ যা আছে সব কারেকশন ঠিক আছে তো এখানে হি
মানে রাউন্ডিং আপ
শুড হ্যাভ বিনটা ঠিক আছে রাইট গুলো থাকবে
কিন্তু আমাদের
Yes.
অবজেকশনটা তো থাকে
সেম অর্ডার
আছে পুরনো
এটা বার করে রাখো
এখানে আমরা অবজেকশন
affidavit service file next matter
Item number 3.
Three Millard, same Millard, similar.
Same thing.
The female candidate.
A female candidate is
Difference of height.
difference of.
Hey, same order. Same order, affidavit service filed. Same order. She হবে। তুমি লিখে রাখো, তুমি আর ভুল করো ভুল। এটা she হবে এটা। প্রত্যেকটা একই কারেকশন করা সম্ভব না। সেম অর্ডার, ইয়েস।
Item number 4.
Four, may I please, Lordship, I am for
Lordship, I'm waiting for the union of tender.
Let here I have made the first PST board. The PST board measure me page 21. Page 21 of my writ application.
Page 21, yes.
21, paragraph 8, first column, height 169.6. My lord, I preferred an appeal. The appellate authority's order is page 22. Without considering and without applying the clause 2D, they have rejected my candidature on shortfall of
But height was measured 169.3.
3. My lord, in PST I have touched cross the borderline.
Maybe, but review order stand. If you have preferred an
If the-
appeal, appeal and the review order is 169.3.
Yes, I what I pray before your lordship, my lord, the
Why you preferred review?
yes, that is the
Why you
candidate.
preferred review? You are within the range.
That is the
Sure.
knowledge of lack of knowledge, my lord. My lord, here the what I am prayed before your lordship is that the appellate authority or reviewing authority may consider the findings of the PST board by applying the clause 2D of their
What is
guideline.
the
As they
clause?
I have crossed the
Issue.
Um,
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as constable GD in Central Armed Police Forces within bracket CAPFS, close bracket. Stop. While in physical on physical measurement, height of the petitioner was assessed as initially as 169.6 centimeter. 169.6 centimeter. Stop. However, petitioner preferred an appeal, and in review order, however, petitioner preferred an appeal, and the appellate authority on assessment of height measured the height of the petitioner 169.3 centimeter, not 169.6 centimeter. Stop. Next paragraph. It is well settled that after preferring an appeal at the instance of the petitioner, at the instance of the appellant, after preferring an appeal at the instance of the appellant, if any order is passed which is not in tune with the order passed by the first authority, the order of the appellate authority remains. Stop. In the present case, though initially height of the petitioner was assessed as 169.3, but subsequently on appeal it was 169.6, but subsequently in appeal it was assessed as 169.3. Stop. Next paragraph. As per norms, a candidate ought to be as per norms, a candidate for becoming physically or a candidate for becoming eligible to be appointed in the post of constable GD is required. Constable GD requires height. Requires height. Required height of 170 centimeter. Stop. In the present case, since height of the petitioner was assessed as 169.3 centimeter, same cannot be rounded up to next higher digit. Stop. Hence, no relief can be granted to the petitioner. Writ petition stands dismissed. Next.
Lordship, this is the same matter, Lordship. Similar matter.
Yes.
Item number 5.
May I please, your lordship, I am for the petitioner.
I'm waiting for the
My
response,
lord,
Lordship.
Same.
Same, Lordship.
Where is the
PST
order?
board, yes. Page PST board 20, page 20 of my writ application.
Page 23 is the appellate authority's order, 169.1.
Yes. And the
That's
page,
page 23, Lordship.
And where is the order of the first authority?
Page 20.
page 20 is the first authority's order.
Yes, issue. Affidavit service filed, ওই ফার্স্ট যে হাইটটা ফার্স্ট অথরিটির হাইটটা 169.5 আর অ্যাপেলেট অথরিটি অর্ডারের হাইট যেটা হয়েছে সেটা 169.1 আর পিটিশনার ইজ এ ফিমেল ক্যান্ডিডেট
No,
male.
here male can.
আদারওয়াইজ সেম
In a male can.
সেম অর্ডার
Item number 6.
6, may I please, your lordship, here also same
Same.
and a female candidate,
ডিসক্রিপেন্সি রিলেটিং টু হাইট
height.
Yes.
And first order is page,
ইয়ে করে দাও তো স্লিপ করে দাও
yes, page 20.
স্লিপ না করো না যেন স্লিপ করো Yes, where is the order of the first authority?
Page 20. Here required height measurement is 157 centimeter.
One 156.5.
5.
Yes.
My lord, 157. Here required height
No,
measurement is
female candidate.
female.
Female.
And on appeal,
In appeal
One
1, my lord, page
56.4.
page
23.
23. 56.4.
156.4. Below 156.5.
Yes.
শোনো, এটা ফিমেল ক্যান্ডিডেট সব জায়গায় সি করে দেবে, অ্যাফিডেভিট অফ সার্ভিস করবে, আর মানে ফার্স্ট অথরিটির হাইটটা হচ্ছে 156.5 সেন্টিমিটার, অ্যাপেলেট অথরিটি অ্যাসেসড 156.4 সেন্টিমিটার, সেম অর্ডার।
Item number 7.
7, may I please, your lordship, I am for the page.
Yes,
Here, my lord, I am paying for not rounding up, but benefit of the clause 2D. Here, the petitioner is the ST category candidate and required height measurement is, my lord, 160, 162.5 centimeter. It is in fraction. I meet
once, what is the required height?
required height is 162.5 centimeter.
Required height,
Required height for
not
ST category,
170.
not
In case of civil trial.
ST. Well, in case of ST,
162.5
height,
is the required height.
required height.
Yes,
My lord, I meet 162. I am paying here, my lord, the benefit of clause,
authority.
first authority.
No appeal
I
was
will-
preferred.
no appeal was prepared on the same date. Subsequent date, he prepared appeal through email on page 22.
On 20th September.
Well, that may be considered by the respondent authority as your lordship also
But you
passed
have
that.
to prefer an appeal. If
Yes,
you
I
have
have
not-
prepared.
Then what,
Page 22.
what was the measurement taken by the appellate authority?
My lord, that
Was
was
not
not considered it as yet.
Till date, no decision. Why?
Lordship, he preferred an appeal on
On subsequent,
after a month.
after the-
not Subsequent date, after a
Very
month.
well, now you considered it. I
mother,
have passed an order, similar order in other matters. Who is to SSC?
my lord, no, my lord,
CRPF.
here when CRPF, nodal agency is CRPF.
But
made
Lordship,
Nodal agency party.
Yes, I have met all of the parties.
Lordship, in case of CRPF, this stage is over. The stage of
No, since the appeal was preferred, then let the appeal be decided by taking measurement, whether this measurement was 162.5 is correct or wrong.
as
Well,
Lordship directed.
My lord, respondent number 5.
So let me give a direction upon the concerned authority of CRPF to take a decision on the appeal preferred by the petitioner by taking measurement of height of the petitioner.
Deep.
And it will be communicated to the petitioner within a short time. Where is the measurement?
Measurement is page, my lord,
Yes,
20.
page 20,
page 20,
male candidate,
male candidate.
yes.
And appeal
162, height
One-
is 162.
2 and required height is
Required is 162.5
62.5.
in case of scheduled tribe,
Scheduled
and
trial,
in case of scheduled caste,
Schedule caste, no relaxation.
No relaxation.
No relaxation. Schedule caste, other backward class, no relaxation.
2024 December selection process.
2025
Five selection. File an affidavit of service.
Yes, this is my.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD in Central Armed Police Forces within bracket for short CAPFS close bracket. Stop. At the time of physical measurement, height of the petitioner was, or at the time of physical test, height of the petitioner was measured 162 centimeter, whereas it is submitted by the learned advocate representing the petitioner that a requisite height for being declared eligible to be appointed as Constable GD is 162.5 centimeter in case of scheduled tribe candidate. So, next paragraph, it is also contended that petitioner preferred. Where is your appeal?
Appeal, my last page 22.
It is online.
Yes, through online.
Through email.
Email.
This measurement was this measurement, when this measurement was taken,
My lord, it was taken
30.
on
the date of page 20,
is it 30th August 2025.
where you are getting this?
My lord, fourth paragraph, point 5.
Point
My lord,
five.
paragraph 5.
Yes, 30th August.
And it was made on online September 20th.
It is also contended that petitioner preferred an appeal questioning measurement of height made by the authority, and same is yet to be decided. Next paragraph. Union of India is represented by learned advocate who has submitted that petitioner made delay in preferring appeal, as a result whereof steps could not be taken. Next paragraph. Having considered the submissions made on behalf of the parties and taking note of the fact that the appeal was preferred by the petitioner questioning measurement of height. Measurement of height as taken on 30 August 2025, which respondent is to decide?
My lord, 5. Respondent number 5 is the head of the
The
notice.
SSC stage is over.
No, not yet is over. The after completion of the nodal agency's work, the SSC work is there for publication of and making a declaration. Not now. This is stage, not this.
Director General, Central Reserve Police Force within bracket CRPF, close bracket recruitment within bracket recruitment close bracket recruitment board. Being respondent 5 is directed to decide the appeal of the petitioner by taking measurement of height of the petitioner. By taking measurement of height of the petitioner, by taking measurement of height by 7 days from date by 7 days from the date of communication of this order, and the decision of the appellate authority or relating to height of the petitioner.
2 weeks may be granted, not 7 days, 2 weeks.
Very well. By 2 weeks, by fortnight from the date of communication of this order, and the decision of the appellate authority on measurement on measurement of height shall be communicated to the petitioner by 10 days thereafter. Stop. Writ petition stands.
My lord, one correction, my lord, paper, my lord. If I succeed, my lord, the next steps, my lord.
Writ petition stands disposed of. If petitioner's height is found to be
Within permission.
within the range. Now, if petitioner's height is if appeal height of the petitioner is measured, which makes the petitioner eligible to be considered for appointment in the post of Constable GD. Consequential steps shall be taken for appointment of the petitioner. Stop. Writ petition stands disposed of. Next.
Much obliged. My lord, item number 13 also, my learned friend is appearing. My lord, item number 13.
Just a minute.
My lord, can it
13?
13?
Yes. 13 to ডাকো তো out of turn.
Item number 13.
My lord, here
Page
page 14.
Just a minute.
My lord, page 14 is the order passed by the appellate authorities.
Page 14.
Page 14. Let BST board measure my height on 169.8. The appellate authority measure my height 169.5. My lord, I am praying before your lordships for rounding off. My lord, similar type matter was taken up, and your lordships also earlier selection.
No, it's not a similar matter. 169.5 appeal, it was 169.5. So it is to be rounded off.
Round.
So let it be taken up
Yes.
serially. I have not passed today's similar order. Sorry.
Sorry, my lord, I am extremely sorry.
Yes. I generally do not permit this prayer to take the matter out of turn. Yes.
Item number
Yes, if
8.
it is exactly same matter, then I take up. Otherwise, not.
Lord, I am for the petition.
Accused is fine.
My Lord, pursuant to your lordship
Just a
direction,
minute. Yes,
my Lord, pursuant to your lordship direction, my Lord.
you have served notice.
Yes, my Lord. They
Yes, yes, yes.
have received, my Lord. My Lord, the petitioner's father was an unskilled labor of the dairy commissioner, product, my Lord. And my Lord, he has been died in the year 2003. My Lord, since the inception of his death, my Lord, he has approached the authority, being a only legal heirs of his father, to get the retirement benefits of his father's, my Lord. Now, my Lord, the respondent authority firstly asked for the succession certificate. My Lord, he has obtained the succession certificate.
You are appearing for the dairy commission.
Yes, my lord. I have Directorate of Dairy Development, wherein, my lord,
No,
this
there's a milk commissioner
milk commissioner.
and state of
My lord, I have received, my lord, from the ex officio deputy milk commissioner.
No, my Lord. No, my Lord, he has obtained.
it appears that it's not a tribunal matter.
Tribunal for the dairy, I don't, my lord, tribunal is there, my lord, I don't think so.
Yes,
Might be, my lord, there is no separate tribunal for dairy.
administrative tribunal. This matter
No, oh,
is it a
sorry.
separate entity
Yes.
which does not come under section 15 of the West Bengal of the
Central
Tribunal Act
Dairy.
1985.
He was a
In which post father of the petitioner was working?
petitioner's
Was
father.
whether the service of the petitioner was governed by West Bengal service rules? Find it out, come back.
Unskilled worker of Central Dairy. Unskilled worker of Central Dairy.
Obtain whether section 15 will apply
Section
or not.
15 will apply.
Obtain instruction.
Yes.
Matter is heard in affidavit of service filed on behalf of the petitioner is taken on record. Stop. Whether father was the employee, whether the father of the petitioner was an employee of state government or not, that is not clarified today. Learned advocate representing the state respondents has prayed for accommodation. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 9th December 2025. Next.
Item number 9.
For the petitioner, my lord. On the previous occasion, my lord had directed for fresh service upon the respondent.
Yes, you are appearing for the petitioner.
Yes,
Yes.
my lord, this is, my lord, arising, my lord, this writ petition arises, my lord, out of an order, my lord, passed on the 4th of November 2022. If my lord comes to page 15 of the writ petition.
Yes. What is the matter about?
My lord, this is with regard to, my lord, confirmation of, my lord, post, my lord. My lord, an order was passed, my lord, in a writ petition, my lord, allowing for confirmation of the petitioner's post. My lord, at page 24, my lord, there is also a point, my lord, that my lord, if I may read, my lord, considering the fact
Just
that
a minute. An order has already been passed on 27 February 2023.
my lord, 27 February 2020.
Page 27. Commissioner Commandant 178 Battalion CRPA.
Yes, my lord.
Whether confirmation has not been allowed.
That has not been confirmed, my lord, since.
So then there is no scope for passing any interim order. Let the matter issue be decided on
Lordship.
Yes. Because this is 27 February 2023 order. In the meantime, 24, 25, 2 years have passed, 2.5 years have passed.
Lordship, he has been confirmed in the rank of CTCQ with effect from 14th July 2008 by this office order number dated
Confirmed.
confirmed.
Where from you are reading?
It is
Page?
no, actually, this is my instruction only.
Just a minute. In that event, let me go through the order passed by the relevant part of the order passed by the Commandant 178 Battalion. Just a minute.
The fact.
Just a minute.
কবে order দিয়েছেন?
এটাই বলছি জুনে
এই বছরে। আচ্ছা।
So this petitioner was taken into the strength of the unit on and from 27 February 2023.
But Lordship, at the time of his confirmation, he was under vigilance inquiry. And thereafter, by the order of the Honorable, actually he was terminated from service. He moved a writ petition and the Honorable Court directed to reinstate him. Accordingly, he was reinstated.
That is the direction passed by the court on
November.
court November 2022.
Yes, Lordship.
Yes, but thereafter this order was passed page 28. Come to page 28. Please come to page 28.
Right now, the copy of it is not available, but
Please come to page 28. Paragraph 6. Page 28, paragraph 6. Read it out.
in compliance with the aforesaid order,
Yes.
Dhananjay Kumar has physically reported unit number 7.
Reinstated into service from the date of reporting in this unit on 27th February 2023.
Lordship,
And no, there is a, please read it. You will get further answers. And taken into the strength of this unit from the same date, that is 27th February 2023. Read it, read it, read it. Don't look at me. Further, the intervening period from 10th of February 2009, that is from the date of termination from service to 26th February 2023, that is the date of preceding the date of his unit of his joining in unit, is hereby ordered to be treated as period spent on duty, spent not on duty for all purposes in terms of FR 54(5). However, the said intervening that is dies non-duty period is hereby condoned for the purpose of pension in terms of Rule 25 CCS Pension Rules 1972 with decision number 1 of the pension under Rule 28 of CCS Pension Rules 1972. Therefore, the aforesaid individual will not be therefore the aforesaid individual will not be admissible for any pay and allowances for the intervening period, that is 10th of April 2009 to 26th of February 2023. So no salary, no benefit, only pensionary benefit was allowed from 10th of April 2009. So why you are saying that in month of June he was taken into the service on 27th February 2023? So why you have come?
My lord, from 27th February 2023, my lord, the post was not confirmed until June 2025, my lord. That is my
Now,
instruction.
today by filing this writ petition, what relief you are seeking?
My lord, only one thing, my lord. If my lord comes to page 24, my lord.
No, the prayer, I don't find anything. Come to prayer C.
Yes, ma'am.
Page 7.
Yes, ma'am.
Read it.
Writ of or in the nature of mandamus directing the commandant 178 battalions CRPF not to give further effect if any office order number such and such dated 27th February 2023.
So this is the office order.
Yes, madam.
So why you are praying for not to give effect to this order,
Lord,
office order?
Only perhaps,
And that too after 2.5 years?
my lord, only perhaps for the reason that, my lord, this office order states that
But it
you will not be entitled
at
to
first blush it appears that it comes in your favor.
my lord, only to the extent, my lord, that it perhaps removes all back wages for the petitioner, my lord.
You did not work at the material point of time. How you are entitled to?
My lord, between 2009 and 2020.
There are judgments galore by the Supreme Court.
Yes, my lord.
If you have not worked, you are not entitled to get the salary. But the pensionary benefit was given from 2009. There's a rationale in it. So far this order is concerned.
My lord, if, my lord, I may then, my lord, take one day, my lord. I do understand there is some update as to the confirmation.
What update? What is your instruction?
As per the instruction, he has been confirmed.
My lord, in 2025, my lord, after the writ petition was filed, my lord, if I may take a day's time as to whether the writ petition, my lord, remains.
Show me, show me. Where is the confirmation order?
That is not attached. Give me 1 week time only to satisfy your requirement.
My lord, if that is, my lord,
file or affidavit of service.
My lord,
affidavit of service filed on behalf of the petitioner is taken on record. Learned advocates representing the petitioner and Union of India. Advocates representing the petitioner and Union of India have jointly prayed for accommodation in order to apprise this court whether petitioner has subsequently been confirmed after the order was passed on 27th February 2023 by the Commandant 178 Battalions CRPF or not.
CRPF.
Stop. Comma দিয়ে CRPF এর পরে comma দিয়ে or not. Stop. Or এর আগে একটা comma রাখবে. Stop. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 11 December 2025. Next.
Great.
Item number 10.
My lord, I am appearing on behalf of the petitioner in pursuance of your lordship's order. My lord, I am again serve notice upon the my lord friend, my lord.
Yes.
Petitioners have been working as a contractual drivers, my lord, initially in CTC, now it is, my lord, West Bengal Transport Corporation Limited. My lord, that your lordship kindly come to page 22. Kindly see what is the condition. Condition was, yes, it was for only one tenure of contract was 1 year. Well, tenure of contractor.
Which
maybe
clause? Page 22?
Page 22.
10 years contract, clause 2.
Initially for 1 year from the date of acceptance, which may be extended on satisfactory performance up to 3 years in total. Malad, thereafter, they have been working uninterruptedly. Malad, the job is perennial in nature and they are working against the sanction post also.
Yes.
Malad, but unfortunately, when they have regularized job of some of the similarly situated employees, they are denying the regularization of this employees, my lord. And my lord, similar.
Still the petitioners are working.
Yes, still working, my lord. Your lordship knows that now Jaggo has come, and prior to that, my lord, our honorable High Court, at least on 3 occasions, my lord, directed for regularization of service, my lord. Your lordship kindly come to page 113. Rajhela, my lord, here the honorable court has directed, because he was working for a long time and the court has directed for regularization on the basis of the direction. My lord, they have regularized the service. Next is, my lord, another is Nitish Anand. In his case also, my lord, they have also Shapon Banerjee.
Just a minute, you are relying upon page 113.
13, my lord. Coordinate bench has directed to consider the case of the petitioner, my lord. They have considered and regularized the service of the petitioner.
Have you made any representation?
Yes, I made representation at page 27.
This is only one petitioner.
Yes, other.
What about others?
Others have also made the representation.
Where are those representations?
Separately, well.
Where are those? Oh, you know. From which date petitioners are working?
2010, 31st July onwards.
So others are similarly circumstanced, other candidates have been regularized.
Not only that, my lord, some juniors have also been regularized. I will kindly come to 180.
So why who is appearing for the West Bengal State Transport Corporation? Yes, why they are not being taken into service on substantive basis?
Orders that my
117 miles, yes.
But the orders that my government is referring, those orders have been carried out only by the state government, because state has carried on.
These orders have been appealed against.
Yes, yes.
117.
Paragraph 9 of the writ petition.
But there is no stay before the division bench, well, even against the contempt application, the contender went to the Supreme Court also, and Supreme Court there remanded back the matter so far the contempt application is concerned, and directed the petitioner therein to address before the division bench in regard to the regularization issue of the regularization.
But some of the candidates have been regularized.
No, some of the candidates I.
Well, let it be, well, appeal be heard.
Well,
Because there
I
are
show you-
several number of corporation, my lord, they are all are coming, my lord. That is why, my lord, Lordship kindly give some time.
Well,
If you are trying to
show
hard
you-
out the appeal, then, my lord, entire matter
I
can
show
be
your
disposed
lordship
of.
that some junior.
Well, exchange your affidavits.
Yes.
Yes, yes. My. Deeply okay.
Petitioners are working, affidavit of service filed on, affidavit of service you have
Yes,
filed
sir.
last occasion.
Two occasion, my lord. Right.
Petitioners are working as drivers,
Yes, sir.
as
Contractual
drivers
driving.
in West Bengal Transport Corporation from 2010 onwards.
10 onwards.
Stop. On perusal of relevant documents, it appears that petitioners were engaged based on an agreement, and such engagement was for a period of 1 year from the date of acceptance, with a provision that in the event of satisfactory performance, tenure of engagement may be extended up to maximum, may be extended maximum up to 3 years. Stop. It is contended on behalf of the next paragraph. It is contended on behalf of the petitioners that though they were initially appointed for a period of for a limited period, but they have been working as drivers from 2010 onwards till date, and the job of the petitioners is perennial in nature. Stop. Next paragraph. It is contended that similarly circumstanced other candidates, some other candidates, including juniors, are favored with regularization. Therefore, petitioners are entitled to get same treatment by regularizing their engagement against existing vacancies. Next paragraph. Mr. Pantu Debrai, learned additional government pleader. And your name? Chaudhuri. And Miss MS Deblina Chottoraj. And MS Deblina Chottoraj. Now, the learned additional government pleader representing the state respondents. And Miss Deblina Chottoraj, learned advocate representing West Bengal
Transport Corporation. Transport Corporation.
West Bengal Transport Corporation
Right.
have jointly submitted that it is true that some of the candidates have been regularized in terms of the orders passed by this court, but on identical issue, appeal is pending before the Honorable Division Bench. Stop. It is also submitted that appeal was preferred by the state government.
Right.
Next paragraph. In view of the aforesaid, in view of the issue involved in this writ petition, this court finds it apt to grant opportunity to the respondent authorities to file affidavits. Let affidavit, next paragraph, let affidavits in opposition to the writ petition be filed by 4 weeks from date. Affidavit in reply thereto, if any, be filed by 2 weeks after ensuing Christmas vacation. Next paragraph, petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next. Diploplasm.
Item number 11.
At the time of call, no one appeared for the petitioner and no accommodation is prayed for. Next paragraph. Same situation prevailed on 11th November 2025. Stop. Next paragraph. The writ petition, next paragraph. It appears petitioner has lost interest. Stop. Next paragraph. Writ petition stands dismissed for default. Parties to act on the server copy.
Item number 12.
In item number 12, Lordship, I beg to appear on behalf of the petitioner. Lordship, the matter is the petitioner is the intended candidate in ICDS, Lordship, and subsequently he got the appointment, Lordship. When this matter was filed, Lordship, then on that occasion, Lordship, he got not appointment, and challenging the same, he has filed his application, subsequently got the appointment, Lordship.
Issue. Learned advocate representing the petitioner submits that petitioner has already been appointed. Stop. Respondents are represented by learned advocates. Next paragraph. In view of aforesaid submission, it appears that grievance of the petitioner stands redressed. Stop. Next paragraph. No order need be. Next paragraph. Hence, no order need be passed on this writ petition. Stop. Writ petition stands disposed of. Parties to act on the server copy. Next.
Here for the petitioner, my lord. This is the appointment related to.
Item number 13.
Wait, but let the matter be called on. Yes, proceed.
My lord, the height related matter, my lord.
Affidavit of service.
Affidavit of service, my lord.
Yes.
Initially, height was measured as 169.8, and then
For
subsequently
appointment in the post of constable GD in CAPFS.
this year.
Where is the height? Where is the document relating to measurement of height by the first authority?
My lord, first authorities, the order is not in the writ petition. They have took it and give the appeal, and in appeal it is 169.
Why the assessment of height of the first authority is not in the writ petition?
They have received it and give the appellate, that is 169.5.
But in other matters, court is getting the order of the first
Yes,
authority.
but this is a peculiar matter, my lord. They have took it. They have asked.
So where is the measurement of height by the authority in
appellate
review?
authority is in 14, my lord, page 14.
14. 169.5. Now what is your case?
My case is I rounding off under the guidelines 2D.
Show me that guideline.
My lord, I do not specifically possession, my lord, but this is the, my lord, Justice Aniruddha Roy has passed.
I want to see the guideline.
The
Orders will come later. First, show me the guideline.
Guideline is mentioned here.
I want to see the guideline.
My lord, I'm physically not possessing the guideline, my lord.
Do you have Mr. Dasgupta guideline?
My lord,
show me the guideline. That is revised guideline of May 2015, perhaps.
D.
Which clause?
2D.
D. What is PST?
Physical standard state.
Test.
সুন্দর অর্ডারটা আছে মেনশন করা আছে
হ্যাঁ মানে অঞ্জুবালার এই যে অঞ্জুবালার
এটাই কি?
অঞ্জুবালার 176 হারিয়ে দিচ্ছে সেটা 169.4 হলো 5 এর কম হলে 5 হলে রাউন্ডিং অফ
Yes, if in review, it was it was found that the height of the petitioner is 169.5, it needs to be rounded up to the next higher centimeter.
Because your lordship has gone through, in one of the cases, we had made detailed arguments. Subsequently, there was the intention to prefer an appeal. Well, our argument here was that this is applicable only for the medical review board. This is not a rounding off is not to be done in PST. Your lordship kindly read that it says it is actually a rounding off below also. So everybody who is measured as one between
169.5 to 169.9.
Anybody who becomes 0.1 or 0.2 or 0.3 will be reduced to 0. It will be reduced to 160. What is it? 160.
No, we are not considering a case where height is less than 169.5.
No,
we are considering a case that where height is in this 169.5 or 169.5, 6, where difference is less than 0.5.
Yes, ma'am. So, my lord, the other single benches have relied on a very simplistic interpretation of this rule. Our argument was that this is to be applied at the time of the medical review board after PST. But because of
it is the order of the reviewing authority's order. This is on appeal. This order was passed.
Yes, yes. No. This rounding off is supposed to be done at the time of medical review. Medical review after PST. Medical board.
That stage has not reached.
No, that will come after this.
After what?
PST. After PST.
So why this has not been done as yet?
No, because he failed in the PST as per our.
So then where is the scope so far medical review board to enhance the height of the petitioner from 169.5 to 170?
That is to be done at a subsequent stage only for the purpose of measuring the BMI. That was our argument.
For BMI is relating to weight.
It also it is weight and by height square, Mel. So
no, but I think it appears that simplistic approach needs to be taken considering clause D. Because it says in borderline cases of overweight, BMI should also be considered to arrive at a conclusion, and variation of 5 kg plus minus from minimum maximum limit may be accepted.
Yes, ma'am.
Similarly, while measuring height, fraction of centimeter less than 0.5 will be ignored, and 0.5 and more will be rounded up to the next higher centimeter. Standard height weight chart is attached. So at the time of measuring height,
this will create an anomaly, my lord.
So measuring height has not been clarified. That at which stage?
That is the ambiguous language in this.
No.
Well,
round it off to 170 and consider the eligibility of the petitioner if petitioner is otherwise eligible.
Yes.
Then you have to specify it in your norms.
There is some
at the time of measurement.
Because otherwise you can see a person who scores even.
It is for granting benefit to the candidate. If it is interpreted in a different manner,
My lord.
Then the benefit which was intended to be percolated in favor of the candidates will not be, that objective will not be achieved.
Well, that is exactly my point, my lord. This cannot be for benefit because if your lordship sees, similarly, while measuring height, fraction of
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD in Central Armed Police Forces within bracket CAPFS, close bracket. Preliminary, there was a written test.
Yes.
In written test, you
First is
qualified.
yes.
In there was a written test was conducted where petitioner qualified, but in physical measurement test,
PST, physical standard
but
test.
in physical standard test within bracket PST, height of the petitioner was measured less than 170 centimeter, which prompted the petitioner to prefer appeal before the appellate authority questioning measurement of height. Stop. Appellate authority measured the height of the petitioner, and VDA order dated 25th August 2025 disclosed, VDA order dated 25th August 2025 disclosed height of the petitioner is 169.5 centimeter. Stop. Next paragraph. It is contended on behalf of the petitioner upon placing reliance on clause 2 within bracket D of the guidelines for recruitment medical examination in Central Armed Police Forces and Assam Rifles dated May 2015, that if height of a candidate is measured in between 169.5 and 169.9, same needs to be rounded up to the next highest centimeter. Next paragraph. Mr. Dasgupta, Mr. Indrajit Dasgupta, learned advocate representing Union of India, has opposed this writ petition on the ground that as per provisions of clause 2D of the revised guidelines dated revised guidelines of May 2015, benefit of relaxation of height needs to be granted at the stage while considering overall physical eligibility of the petitioner, taking note of the weight of the petitioner. Stop. According to the Union of India, according to the respondents, that stage has not yet reached. Stop. It is also submitted since petitioner's height in appeal was measured at 169.5 centimeter. At this stage, petitioner is not entitled to get benefit of clause 2 within bracket D of the revised guidelines. Next paragraph. Having considered the submissions made on behalf of the parties and taking note of the provisions as contained in clause 2D of the revised guidelines, it appears that it is specifically provided while measuring height, fraction of centimeter less than 0.5 will be ignored and 0.5 centimeter and more will be rounded off to the next higher centimeter. Stop. Next paragraph. In the present case, it is true that in appeal, height of the petitioner was measured as 169.5 centimeter, which is less than 0.5 centimeter of requisite height that is 170 centimeter. Stop. But applying the provisions as contained in clause 2D of the revised guidelines, petitioner is eligible to get benefit of clause 2D, and height of the petitioner, which was found as 169.5, is required to be rounded off to next higher centimeter, that is 170 centimeter, being the requisite height. It is specifically stipulated in clause 169, it is specifically stipulated in clause 2D that at a time of measurement, relaxation relating to height as contemplated therein needs to be extended in an appropriate case. Next paragraph. In aforesaid context, concerned respondent authorities are directed to treat the height of the petitioner 170 centimeter by rounding it off as contemplated under rule 2D or clause 2D, and if petitioner is found otherwise eligible, steps shall be taken for appointing the appointment of the petitioner in the post of constable GD in CAPFS. Stop. Next paragraph. Writ petition stands disposed of. I am keeping this rule. Just after putting signature, you will get it back.
My lord, kindly give them a direction for a time frame to complete the exercise. My lord.
Because various appeals are pending, we do not know when.
No, sorry. There will be a difficulty, Mr. Dasgupta.
All matters, my lord.
Next paragraph.
Because
I will grant you enough time.
Because
affidavit disposal line করে দাও. Aforesaid exercise shall be completed by the concerned respondent authorities by 8 weeks from the date of communication.
The last stage, there are various things pending. Appointment.
Complete DME তো চলছেই
They have delayed the whole process.
No, my lord, DME
From August they have coming and challenging.
Very well, 12 weeks.
My lord, DME is going to end on 3rd December.
12 weeks.
3rd December, DME will complete. So
8 weeks to 12 weeks করে দাও. So that an opportunity is to be extended to the respondent authorities to test my order before the
let them
higher authority. Yes. Next. No, that is your right.
No.
The appeals are pending, and if there is an order of the honorable division bench, that will govern the field, obviously.
That will, this case also will come under that.
Item number 14.
Lordship, this was my application. The last occasion, your Lordship was very kind to accommodate us. Lordship, but there is one innocuous error in this writ petition. Lordship, the issue that arises over here, your Lordship, is the accommodation that has been provided to me for meeting out benefit services to the accommodation, official accommodation that is provided to me for meeting out benefits of my service with the Indian Naval Forces. Your Lordship, the Union of India ought to have been made a party over here because, your Lordship, under the Navy
I am
Act,
representing all respondents for the Ministry of Defense are not required to be.
Your Lordship, just then one more thing, your Lordship, I will probably have to seek your Lordship's leave to file a supplementary affidavit because, your Lordship, the issue at hand over here is, your Lordship, that an accommodation was given to me. I had elapsed the time period for that accommodation.
Member of Indian Naval Force.
I am a commander in the Indian Naval Forces. Your Lordship, I'm stationed in Visakhapatnam at the time being. Your Lordship, I was given a particular accommodation. Your Lordship,
where?
Your Lordship, in Baliganj. Your Lordship, a certain category.
If you are stationed in Visakhapatnam, then
But
why
Your Lordship, my
this
family-
accommodation is
family
given at
is-
Baliganj, Kolkata?
Family is here. So I am entitled to that accommodation, Your Lordship. Your Lordship will appreciate that, Your Lordship, in terms of hard posting, Your Lordship, the person concerned or the service concerned, Your Lordship, I am entitled to retain an accommodation in my hometown. Your Lordship, even for Your Lordship, all services. So Your Lordship, over here, I was stationed in Visakhapatnam. I was married at the point of time. Subsequently, Your Lordship, my marriage is dissolved. Your Lordship, I was staying with my parents. So I'm entitled to a certain category when I'm married. Your Lordship, when I'm staying with my parents, the status in which I am going back to is that I am an unmarried serving officer. But Your Lordship, I had put in a representation to the effect that since my aged parents are there, kindly allow me to retain this accommodation. Your Lordship, subsequently, a writ petition was filed before this Honorable Court. This Honorable Court was pleased to enlarge the time by which I have to vacate that accommodation. However, Your Lordship, in the interregnum in 2022, there is this SADS rule which governs the accommodation of the Indian Navy, SADS rule of 2022 that comes in, by dint of which I am entitled to keep this present accommodation. Your Lordship, on that.
So
But the
your case is
unfortunate
that the
part,
situation is altered
the
because
altered.
of this subsequent
The
rule.
subsequent rules which have come into being, and Your Lordship, that is in
Prior
supersession.
to that rule, you are not eligible.
I was not eligible.
But
Your Lordship.
already, as you have said that submitted that there was a writ petition where the decision has already been taken to vacate.
Your Lordship, over there, the time period was enlarged. That writ petition was agitated in 2022. Your Lordship, subsequently, this rule has come into being. So, as of today, I am entitled to that accommodation. Your
But
Lordship,
what will happen to the order passed by the court and bench?
Your Lordship, that writ petition was with respect to. No, that was a.
Then you ought to have filed a review petition.
No, Your Lordship,
or
that
an
was
appeal
with respect to an.
in view of the changed circumstances.
Changed circumstances, but Your Lordship, my cause of action emanates around out of a particular representation which was given to the respondent authority. So the representation over here is subsequent. Your Lordship, the issue that I'll be facing today, Your Lordship, the SADS rules.
Order is at page 26.
Your Lordship, the order, Your Lordship, is that the impugned is 38 and then
Of the earlier petitions.
38.
Not page 26.
No, Your Lordship, page 26 is the first order, which is 22nd December 2022. 38 is the subsequent order, Your Lordship, 21st June 2023, Your Lordship. Your Lordship will kindly take that up once.
Page at 40, ordering court. From the last minute.
Just a minute.
No. I know. No, but for that we can't agitate. Review for now.
So whether the type A accommodation has been vacated?
Your Lordship, it has not been vacated. I must
Why?
claim it has not
Then
been
order
vacated
dated
despite
21st
the
June
order of the court.
2023?
And Your Lordship, very candidly, Your Lordship, I will not come to defend that aspect. Your Lordship, show cause notices were issued to me. Your Lordship, again on the.
Tell me when you will vacate it.
Your Lordship, today, Your Lordship, my cause of action is different. Your
Sorry.
Lordship. Because Your Lordship, today I am
Sorry,
challenging.
this is your
show cause-
your
That was my
application
prayer, Your Lordship.
that
I
that
will not.
to allot type B flat, type B accommodation.
No, Your Lordship, that I cannot quarrel with. Your Lordship, the
So
only
therefore,
aspect that I'm agitating.
ought not quarrel. Tell me that when you will vacate it.
Your Lordship, Your Lordship, I am my limited prayer over here, Your Lordship, that subsequently, and Your Lordship, I am in no pedestal over here to, Your Lordship.
Since
pray for
this
your
order stands as on date.
Your Lordship, but this order was with respect to a previous demand for justice that I had preferred before the respondent authorities. Today I am
Petitioner
challenging.
has himself made a prayer for allotment of type B quarter either in the end of June or mid-July.
Your Lordship, that aspect, I am acceding to that aspect, Your Lordship. What I'm praying before Your Lordship today is, Your Lordship, that was with respect to a prior demand for justice. Today, the rules are otherwise, Your Lordship. So
But
today I am
subsequently,
challenging.
the state officer was appointed, he has acted upon, declared.
If you would have complied with the order, you would not have been able to take the benefit of the rule if I proceed on the premise that the situation is changed because of the rule. So therefore, the delay which is deliberately made by the petitioner after the order was passed on 21st of June 2023, petitioner is not entitled, or petitioner should not be permitted to take the benefit of the delay caused in shifting.
Your Lordship, I cannot, Your Lordship, as an officer of the court, Your Lordship, I cannot justify this conduct, Your Lordship. Perhaps, Your Lordship, this limited circumspect in which, Your Lordship, I am praying for Your Lordship's charity over here is only on the basis that Your
No,
Lordship.
it's not a question of charity. Mr. Counsel, when an order was passed based on
No, Your Lordship, it ought to have been complied.
considering your prayer for shifting, it should be
No, Your Lordship,
given
it ought to have been complied. But Your Lordship will kindly just give me the liberty.
The state officer passed an order directing him, declaring him as an unauthorized occupant with regard to the premises and government quarters, because we are unable to provide the quarter to other personnel.
No, Your Lordship, that Your Lordship, my learned senior cannot come over here and agitate. It's my writ petition.
License fees. He has to pay the damage and all the costs. And
That's an ancillary aspect, Your Lordship, and probably with the Your Lordship, all humility.
But you need to vacate the A type quarter.
Your Lordship, Your Lordship will just kindly consider that subsequently today my cause of action is
You
emanating
tell
out
me
of
that when the new rule came in
2022. Now, Your Lordship, the only reason June 23, learned, Your Lordship, my learned senior who was appearing back then ought to have brought those rules to the notice of the court. It was not on record before that court, Your Lordship. Today, Your Lordship, I am challenging the show cause notices that have been issued to me on the basis that it falls foul of those rules. Your Lordship, today, one more aspect, Your Lordship, those rules which has been pleaded as Annexure 13, somehow, Your Lordship, the annexure that has been annexed is something else, Your Lordship. So, Your Lordship will just kindly give me the liberty to come up with a supplementary affidavit. Just satisfy Your Lordship on that limited point. Give me a day's time. I'll file a supplementary affidavit to that limited circumspect, Your Lordship, because today my cause of action is not the cause of action that was agitated before the earlier writ court, Your Lordship. It's a different cause of action.
I have to take out the point, raise the point on the point of maintainability of the writ petition before this Honorable High Court. These Honorable High Court cannot exercise jurisdiction under Article 226 of the Constitution because the remedy lies under the AFT, Armed Forces Tribunal. Because he's the.
Your Lordship, the remedy will lie under the Armed Forces Tribunal. Your Lordship, the remedy will lie under before the Armed Forces Tribunal only with respect to the fact that if I'm court-martialed on account of such breach, which has been done.
First, this writ petition is not maintained. The remedy lies under AFT Act.
Your Lordship, I am agitating a fundamental right violation. How can a writ petition Godrej
absolutely barred by the principle of res judicata? If Your Lordship kindly consider the relief claim in the prayer portion of the writ petition, the same the relief claim in the earlier writ petition, which has already been decided.
Your Lordship, I am urging my learned friend to come and show that. If it's the same thing.
First line of the order dated 23rd June 2023, that what he has challenged in that writ petition, order dated 18th May 2023. And I can see the prayer in the present writ petition, prayer A. The same order he has challenged. So absolutely barred by principle. This point has been decided by this Honorable Court.
So in your previous writ petition, notice dated 5th May 2021 and 18th May 2023 was under challenge.
Your Lordship, that was not specifically under challenge. Your Lordship, today I am
the previous writ petition.
Your Lordship, in the previous writ petition, same challenge nahi tha to.
Has to be.
Your Lordship, ye kaun sa notice hai? Show cause challenge. Your Lordship, today, Your Lordship,
the present writ petition kindly.
Stay of an order dated May 18, 2023.
Your Lordship, this was in light, Your Lordship, because of a subsequent cause of action, Your Lordship.
What subsequent?
Your Lordship, that is what I'm agitating over here.
Kindly direct him to vacate the premises. It's a public premises.
No, Your Lordship, may I just pray for this, Your Lordship? May I withdraw this writ petition? Your Lordship, may I withdraw this writ petition with the liberty to file afresh, Your Lordship, challenging the show cause notice and Your Lordship to give out the relevant rules. Your Lordship, perhaps I won't require that liberty because, Your Lordship, it's a different cause of action.
No,
so, Your Lordship,
Mr. Counsel.
He has challenged, assuming that the estate officer's order Well, that is also, the deputy doesn't like for this honorable court.
No, of course it does, Your Lordship. I am agitated.
I will permit you to withdraw the writ petition, but
I will-
with the leave granted to the petitioner
To take
the
necessary
respondent
steps
authorities
in
to take
accordance with
steps
law.
in terms of the order date 21st June 2023.
But he has to vacate.
Your Lordship,
To take
so Your
steps
Lordship, in
in
my
terms
writ
of this
petition,
order.
he
It is
cannot
not
pray
your
for
writ
an.
petition. Very well, let the writ petition be withdrawn and dismissed with the liberty to the respondent authority to take steps in terms of the order 21st June 2023.
Your Lordship, that is probably already been done.
Sure.
Your Lordship, will just kindly give me the liberty to withdraw, not dismiss, Your Lordship, kindly. Just to withdraw.
No,
I'm
withdraw means dismissed as withdrawn. Dismissed as withdrawn.
Your Lordship,
Not dismissal on merit.
Lordship, I am good.
Matter is affidavit of service.
Your Lordship, affidavit of service.
Matter is
Your Lordship, they are appearing.
very well. Matter is heard in presence of the learned advocates representing the parties. So, during course of hearing, Mr. Chakraborty, learned counsel representing the petitioner, has prayed for leave to withdraw the writ petition. So, on the contrary, Mr. Nondi, learned advocate representing respondent numbers, representing the respondent authorities, has submitted based on order dated 21st June 2023 passed by a coordinate bench on the writ petition filed by the petitioner being WPA 14142 of 2023 for vacating A type type A quarter or type A accommodation which was provided to the parents of the petitioner. Stop. Considering the submission made on behalf of the petitioner, writ petition stands dismissed as withdrawn. However, such order shall not preclude the concerned respondent authorities to take steps in accordance with law for vacating the quarter in question.
Grateful. All this to attain final.
Item number 15.
My lord, I'm from the petitioner.
Yes.
And I'm for the respondent authorities also.
The petitioner was an employee of Food Corporation of India and superannuated
Employee of
Food Corporation of India.
Food Corporation. You are for the FCI.
My lord.
He was superannuated on 31st March 2023 after rendering 35 years of service.
When retired?
31st March 2023.
23.
23. After rendering 35 years of service. When he was appointed on 31st November 1987, he was under Central DNS Allowance Pattern.
Central
DNS Allowance Pattern.
Central DNS Allowance
Pattern.
Pattern.
But
CDA.
During his service period, circular dated 30th September 2011, please, my lord, see page 20 to 22, wherein he was converted from Central DA pattern to Industrial DA pattern.
IDA. Yes.
By page 20 to 22, and the circular is then and page 24. And accordingly, fixation was made. Fixation dated 24th May 2012, and pay was fixed from 11th January 2002.
First promotion. So in terms of this circular, you are permitted to switch over from CDA pattern to IDA pattern.
Yes.
Now, what is your grievance?
My grievance is I was not paid the area. Please see the pay fixation.
You are not paid?
The pay fixation areas for the period of my first promotion, that is on 11/1.
Pay fixation areas, yes. For which period?
From 11/1/2002 to 31st December 2011.
31st December
2011.
11 January 2002 to 31st December 2011.
from 1/1/2002, I
According to you, why this was not paid?
not paid.
Why this was not paid?
It is FCI can.
Suppression of facts, material
So-
facts matter. I'll submit.
But you retired on 31st of March 2023. The period which you are complaining of non-payment of dues,
Huh.
that is from 11 January 2002 to 31st of December 2011.
Yes.
So why during your tenure you did not raise objection?
Yes, letter was issued.
After retirement in 2023, you are coming in 2025
But-
relating to a period non-payment of ADR for the period from 2002 to 2011.
During the service period, he issued some letters. Please see the letters, my lord. He already issued letter to give him the arrears. But FCI denied the payment. But in the fixation, it was clearly written. Can you see the fixation page, my lord? At page 23, the difference of pay allowance may be paid as admissible as per rules.
So petitioner is claiming ADR, why it was not paid?
My lord, at the very inception, I submitted there has been suppression of material facts. And perhaps, my lord, the material facts my learned friend has willingly suppressed, and I'm sorry to tell my lord, my learned friend is also party to the other proceedings, which is pending before the division bench of this honorable court. My lord, facts remains, this particular circular on which my learned friend is relying upon is no more in force, my lord. Subsequently, different circulars came into force, whereby, my lord, all the areas, my lord, the salary portion has been put on hold because of the conversion. Because of the fact, my lord, there has been a batch of writ petition has been filed, either challenging the first circular or, my lord, for implementing that circular. So therefore, my lord, the
First circular means 7 December 2011
yes,
circular.
my lord, first, my lord, in 1990, first Supreme Court passed a decision, my lord, for the purpose of converting the pay scale from CDO to IDA. So, my lord, in 2009, the Departmental of Public Enterprises first sent a notification informing us that the food corporation is also falling under that similar, my lord, provision. Therefore, my lord, in 2011, we came out with the first circular on 30th September 2011, giving opportunity to all the employees to convert from CDA to IDA. Thereafter, my lord, 2012, the few of the my lord, the employees or ex-employees had challenged implementation of this circular.
7 December 2011.
Yes, my lord. 12, my lord. In 12, my lord.
2011, 7 December 2011 circular, page 24.
Yes, my lord. Yes, 30th
Yes.
September 2011 circular has been challenged by few of the, my lord, the ex-employees on the premises that those implementation of the circular was adversely affecting their career so far the ADR part is concerned. Thereafter, few other also, my lord, ex-employee came up for the purpose of implementing that circular, my lord. At present, my lord,
This 7 December 2011
yes,
circular.
same circular, my
So
lord.
there were cross writ petitions.
Yes, my lord, at present, my lord, there are total 5 writ petitions pending before the Delhi High Court, and my lord, hundreds of, my lord, parties are there, my lord. In the wake of several orders passed in the Delhi High Court, my lord, writ petitions, first, my lord, the circulars were put on stay. Thereafter, the stay was vacated or modified, and, my lord, the conditional order was passed, whereby, my lord, the Delhi High Court has given an opportunity to FCA to recover the excess amount because of the conversion from CDA to IDA. But so far, the, my lord, ADS part is concerned, my lord, we are allowed to withhold those payments. So in the wake of that particular, my lord.
So let the representation of the petitioner be considered.
My lord,
You can disclose the reasons why this was not paid to the petitioner.
My lord, from 1/1/12, he was paid full pay and allowances.
No,
From 1/1/22 till
on the conversion,
retirement,
it is only about the
he was
areas,
paid
my
full.
lord. Yes,
31st
I admit.
March.
It is only about the
he was
areas.
paid full.
My lord, he has not
And sir-
got that circular.
That is the prayer, also prayer. That is the prayer
Yes,
that
areas, because areas
you
have been-
take a decision on the representation of the
without going into the merit of this petition. My lord,
yes, all points will be kept open.
Yes.
So you disclose that these are the difficulties for which steps could not be
My-
taken
my-
for
I-
payment
I'll
of area in terms of
otherwise
this
I can also come up with
circular dated 7 December 2011, because that will be precisely your grounds in the affidavit in opposition if opportunity is given. So no use of keeping this matter pending. After disclosure of the
Or I
reasons,
can also
if
come with
there, if that
representatives.
order goes against the petitioner,
Then
or
he
if
can come
petitioner
to us.
finds that his right is being infringed, then he can take steps in accordance with
But
it.
my lord, kindly.
But at this stage, it will not be proper to enter into this issue once it, since it is not been considered by the authority from the administrative side.
Certainly, my lord.
Where is your representation?
My representation.
Have you made any representation for seeking a grant of area?
Yes.
Legal notice
Please
has been
keep
given.
Legal notice will
29
not
to
do. I
30.
do not permit legal
No,
notice.
29 to 30, just see, my lord. 31st 11/2014, page serial 29, my lord. 29 and 30.
2014 representation. That will not be found in the office of
During
the
his service.
authorities. You make a fresh representation within certain time, that will be considered
Yeah.
by the authority. Which authority will consider it?
No, the fresh, on the 31st July 2020.
General manager, respondent number 2.
Huh?
My lord, I am divisional general manager, my lord.
Respondent number 2.
My lord.
Issue. Affidavit of service, file your affidavit of service. Where is your affidavit of service?
Already given.
File. Petitioner was an employee of,
My lord, just I am telling you, he's a class 4 employee, and he is
was an
suffering from
employee of Food Corporation of India, who retired on superannuation on 31st March 2023. He has stopped. Petitioner has come up with the present writ petition claiming arrears accrued due to switching over from CDA pattern to IDA pattern, which was permitted by the concerned authority of Food Corporation of India in terms of circular dated 7 December 2011, which is at page 24 of the writ petition. According to the petitioner, since petitioner availed of the opportunity of switching over from CDA pattern to IDA pattern, CDA pattern scales of pay to IDA pattern scales of pay. He is entitled to receive area dues for the period from 11 January 2002 to 31st December 2011. Stop. FCI is represented by learned FCI is represented by learned advocate who has opposed the writ petition on the ground that there are pendency of issue before the before the court.
Delhi High Court.
Stop. It is also submitted that stop. Next paragraph. Having considered the submissions made on behalf of the petitioners, this court finds no purpose would be subserved in keeping this writ petition pending. Next paragraph. Leave is granted to the petitioner to make a representation to the General Manager, West Bengal, Food Corporation of India, being respondent 2, claiming area dues due to switching over from CDA pattern scales of pay to IDA pattern scales of pay by fortnight from date. Stop. If such representation is made within the aforesaid time, respondent number 2 shall decide the same in accordance with law by 8 weeks thereafter, after granting opportunity of hearing to the petitioner or his representative, and a reasoned decision shall be passed, which shall be communicated to the petitioner by 10 days thereafter. Stop. It is made clear that court has not entered into the merit of the claim of the petitioner, and all issues are kept open. Stop. disposed or writ petition stands disposed of, Arjun.
Since affidavits are not, my lord, extend the
একটা করে দাও, since affidavits are not called for, allegations contained in the writ petition are deemed not to have been admitted.
Actually,
কালকে ওই CPA proceedings এর মামলাতে তো বেরিয়ে যেত, কারেকশন গুলো পরে করলাম। Actually, 2 weeks এ যে affidavit in opposition রিপ্লাইটা ছিল, ওটা কিন্তু আমি বলেছিলাম, নাহলে ওটা ওই ক্রিসমাস ভ্যাকেশনের মধ্যে পড়ে, ওইটা কারেকশন করলাম বলে অন্যগুলো, না হলে ওটা আমরা কিন্তু পরেরটা খুব সুন্দর করে দিয়েছি, বুঝছি
ডেভেলপ
ওই জন্য আমি করলাম। ঠিক আছে, যখন হবেই কালেকশন তাহলে
kindly please to release the matter.
Airport. You have challenged the order of the Labour Commissioner. Learned advocate representing the petitioner submits that the issue involved in this writ petition relates to Group 3 of classification and list of different types of writ proceedings. Stop. Next paragraph. Respondents are represented. You are for the state.
Respondent number 2.
Respondent number 2 is represented by learned advocate. Next paragraph. Hence, writ petition stands released due to want of determination and be placed before the appropriate bench. Next paragraph. Leave is granted to the learned advocate representing the petitioner to amend the presentation form and pro forma page of the writ petition and reclassify the same as Group 3 matter.
Item number 17.
My lord, I am for the petitioner. I am praying for not today only.
Why?
Due to illness of learned senior advocate Amitabh Chaudhuri, I am praying for time.
My lord, only one thing, if I may say, I don't think that should be a problem. My lord, will kindly take the cause title once. Number 1 is Managing Director and CEO of Bank Maharashtra, which is correct. Number 2, Managing Director and CEO of Kolkata. My lord, the bank has only one Managing Director who is in Mumbai, no doubt. We do not have a second Managing Director. And now, my lord, we are carrying the wakalat signed by the general manager who has the authority from the managing director to execute. But unless he's made a party, we cannot file this. So, my lord, if that amendment can be just done here.
Petition with the assistance of your learned friend.
Sir, numberটা managing director না হয় শুধু general
You are the
manager.
advocate on
Regional.
record. Yes, are you the advocate on record?
No.
Who is the advocate on record?
Amitabh Chaudhuri.
Then there's a difficulty.
No, my lord, tomorrow then.
Issue. At the time of call accommodation, Mr. Chaudhary will be able to come tomorrow.
Yes.
At the time of very well not to
Very well.
not to the same thing, not to. He is ill for the day only. Yes.
Item number 18.
Come tomorrow.
Item letter I for the petitioner lordship led by Mr. Anjan Bhattacharya. Last occasion lordship, my other side had prayed for that IDBI bank is a private bank lordship. So that so I'm the advocate lordship kindly leave granted to withdraw the matter and file a fresh to appropriate.
What file a phrase? Your
But I
petition is not
file a
maintainable?
No, lordship.
Be
For
against
the
private
appropriate
bank?
forum lordship, not for the High Court lordship. Because it's a private bank lordship, so give me grant leave, so I can.
Take steps in accordance with law.
This is my.
Madam, I'm handing over this
Bingo.
categorization.
Not required at the time of call, learned advocate representing the petitioner pays for leave to withdraw the petition and to take steps in accordance with. Bank authorities represented by learned advocate. Next paragraph.
And there is a coordinate.
There are... Please don't disturb this court. In view of aforesaid submission made on behalf of the petitioner, writ petition stands dismissed as withdrawn with leave to take steps in accordance with if the grievance of the petitioner is not redressed. Next paragraph. Parties to act on the server
There is a coordinate bank judgment also to that effect. It is DRT or something.
Next.
Item number 19.
Who is for the petitioner?
Sir, I am for the union, but perhaps I am not the answering respondent. The answering respondent is the bank.
You are for the central bank.
No, my lord, I am for the Union of India. Respondent number 3.
But who is for the petitioner? At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. However, Union of India is represented by learned advocate. Next paragraph. In order to grant one more in order to grant one more chance to the petitioner, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 9th December 2025.
Grateful, my lord.
Next.
Sir, আপনি petition নিছেন? আমি
Item number 20.
Item number 19.
9th December. Item number 19.
Lordship, my presence be recorded.
Yes, 19.
Item number 19. On behalf of respondent bank.
ব্যাংকের হয়ে ওনাকে করবে। However, Union of India and bank authorities are represented by learned advocates. Same order. Next matter. I thought you were appearing for the petitioner.
Lordship.
Item number 20.
20, my lord, is my application.
My lord, 20, my lord, Mr.
lord.
Sukanta Chakraborty is appearing for DVC, my lord. My lord, we have received, my lord, the brief, my lord, yesterday, my lord. We are yet to my lord, get any instruction, my lord. If your lordship.
My lord, very well, my lord. Only indulgence I am seeking, my lord. My lord, respondent number 6 to 13, my lord. My grievances are twofold: denial of promotion and supersession by junior employees. Now, my lord, 6 to 13, my lord, are the junior employees who have been allowed to supersede me. My lord, I made an endeavor to serve them, my lord, through the employer. My lord, the consignments have been returned, my lord, with an endorsement, addressee left without instruction. Now, my lord, the employer sent an email to my advocate on record, asking the advocate on record to send it to their residential addresses. My lord, I have also, my lord, responded by an email seeking to know, my lord, the residential addresses so that the service can be effected, because the employer is privy to such information. Let that information at least be, my lord, given to me so that the matter can be effectively heard by your lordship. And I don't think they will have any problem to.
Lord, that we can do.
To provide the residential
Details.
addresses of the
Lordship.
private respondents
Lordship.
for completing service of notice upon the respondents.
Lordship.
In the meantime.
Lordship.
And come back on a particular date.
My lord, now kindly keep it after a week, my lord.
But kindly keeps it after 10 days.
Yes, yes, it will take some time. to
Lordship.
complete
7
service.
days time.
Learned advocate representing the petitioner prays for direction which would permit the petitioner to complete service of notice upon respondent numbers
6 to 13.
6 to 13 by sharing residential addresses of or by sharing residential address of these respondents by the learned advocate representing Damodar Valley Corporation. Stop. Learned advocate representing Damodar Valley Corporation is directed to share a residential address of respondent number 6 to 13 by
By my lord, kindly grants us a week's time, my lord.
Week's time.
My lord,
My lord, I tell your lordship, my lord, today is Tuesday, but by Friday, my lord, we shall keep it.
By 28th November 2025. Stop. On receipt of residential address of the respondents, of the aforesaid respondents, learned advocate for the petitioner is directed to serve notice upon those respondents from date and file affidavit of service on the next date. Release the matter under the same heading for further consideration on
possible for your lordship to prepone the date, my lord.
10 days you require because there are private respondents, you complete service.
With regard to item number,
matter.
item number 19, my lord.
Sorry.
May I place the affidavit of service, my lord, on it?
কি হলো item number?
20.
Yes, affidavit of service filed on behalf of the petitioner is taken on record. Next.
Item number 21.
My lord, item number 20, I am appearing for Union of India. I am seeking one more time, my lord. Yesterday I received the brief, my lord, for instruction. My lord.
At the time of call, learned advocate representing Union of India has paid for accommodation prompted instructions. Hearing of this matter stands adjourned. Establish the matter on the same heading for further consideration. On. Third December 2025. Next.
Item number 22. For the petition in this matter. This is also another matter of where I am also paying stay of the disciplinary proceedings during pendency of the criminal proceedings. The copy has been served, and I also requested my learned friend to appear because they were not appearing since my lord. 28th matter was
I
taken
have
up.
received instruction from my Coal India Limited to appear on behalf of the Coal India Limited, but copy of the writ petition not available with the one copy is.
At the time of call, filed affidavit service. Affidavit service filed on behalf of the petitioner is put on paper. Stop. At the time of call, learned advocate representing Coal India Limited.
Also, my lord, I got the information, instruction over telephone today morning to appear on behalf of the Bharat Coal Coal Limited also. Both are requested, they are not available, the writ petition.
Coal India Limited and BCCL has
Don't go
paid
repeat.
for accommodation to instructions. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 3rd December 2025.
Get full, my lord.
Next.
My lord, in the copy to leave sharp. At other actors. আজকে দিও আমার actually marriage occasion going on in my house, my lord. Are you asking if today is
Go outside and sort it out.
Item number 23.
On earlier occasion, it was heard by your lordship.
My lord, in this matter, I am led by Mr. Manishi Mukherjee, my lord, if your lordship grants not today in this matter, my lord.
And another thing, it struck my mind that I want to see this rule 5483 of CCS pension rule. Which has been referred to in the order dated 7th April 2025.
My lord.
Come to page 22. As per rule 5483 of CCS pension rule, 59D and E of CCS pension rule 2021. When the pension to the children shall be payable in order of their birth and younger of them will not be eligible for them. I want to consider this rule.
My lord.
Have you? Do you have the copy of this rule?
Yes, I have annexed.
No, rule.
Lordship
is asking for the
rule. I think that it will be required while adjudicating the validity and legality of this order dated 7th April 2025.
My lord.
Issue. At the time of call, learned advocate representing Union of India.
My lord, Union of India.
Union of India has paid for accommodation. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 2nd December 2025.
My lord, so one indulgence, if this may be added that for producing the rule, I have paid for indulgence.
No, not at all. Why?
Item number 24.
Produce the rule at the time of
My lord,
hearing of this matter.
My lord, I'll produce the rule. My lord, I'll assist. My lord, I'll produce the rule.
In item number 24 on appearing for respondents 1 and 2. In my respectful submission,
respondent
1 and 2.
I am for the petitioner, my lord. The matter is regarding non-disposal of the appeal, statutory appeal.
Cooperative matter is before.
Yes.
In my respectful submission, this matter pertains to cooperative service, cooperative determination
My
of
lord,
group
it
5
is
matters.
filed because this is a service matter. My lord, please, I will correct the presentation form and the cost.
Clause 5 of group 5, my lord.
Learned advocates representing the parties have jointly submitted. Learned advocate representing the petitioner and respondent number 1 and 2 have respondent numbers 1 and 2 have jointly submitted that the issue involved in this petition pertains to cooperative service under groups 5 of classification list of different types of writ proceedings. Next paragraph. Hence, writ petition stands released due to want of determination and be placed before the appropriate bench. Next paragraph. Leave is granted to the learned advocate for the petitioner to amend the presentation form and pro forma page of the writ petition and to pro forma page of the writ petition to classify the same as group 5 matter.
Great.
To reclassify the same as group 5 matter.
Great.
Item number 25.
Leave me granted to withdraw this petition with the central government. This is compensation matter. This is central government. So this perhaps not your Lord's tribunal.
We are happy on behalf of the state.
At the time of call, learned advocate representing the petitioner
My
applies
affidavit
for
says.
leave to withdraw the writ petition and to move the central administrative tribunal. Next paragraph. Respond. Union of India. You are representing Union of India.
I'm appearing on behalf of the state.
Yes.
State. I'm appearing on behalf
My affidavit service.
State government.
Central government. Union of India.
The department of. Then why the state is represented?
Well, district magistrate is incorporated as a party respondent and block development officer.
Both of you are representing 5 and 6.
Fine.
5 and 6.
Fine.
Both are representing state.
Yes.
And to move the central administrative tribunal. Stop. Central Administrative Tribunal, Kolkata bench. Stop.
I'm grateful.
Respondent numbers 5 and 6 are represented by learned advocates. Next paragraph. In view of aforesaid submission, made on behalf of the petitioner, writ petition stands dismissed as withdrawn. Stop. However, this order shall not preclude the petitioner to move Central Administrative Tribunal on the self-same cause of action.
My affidavit service be kept.
Service টা করে দিন। Next.
Item number 26.
Well, item 26, my lord, I appear for the respondent, WBSEDCL.
WBSEDCL.
Yes, my lord.
Who is for the petitioner?
My lord, we have to check. I think Mr. Shamim Ahmed is the learned advocate for the petitioner.
Are you aware of? Where is Mr. Ahmed?
No, my lord. He is supposed to assist me in another matter, but I don't know his whereabouts right now.
That's why I'm asking him. You are appearing for the state.
Yes, sir.
At the time of call, no one appears for the petitioners and no accommodation is paid for. However,
26.
where is Mr. Ahmed?
On his legs.
Come back on another date.
26.
Is whether Mr. Ahmed is coming?
I told inform him.
Then, my lord, kindly post it on another day, subject to your lordship's convenience, my lord. Subject.
Learned advocate representing the petitioners prays for accommodation. Stop. However, state respondents and WBSEDCL are represented by learned advocates. However, state respondents are represented by learned advocate. WBSEDCL is represented by Mr. Mojumdar, learned senior advocate. Is represented by Mr. Mojumdar, learned senior advocate online or on virtual mode. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 2nd December 2025.
Great.
Next.
Item number 27.
I am for the petitioner in this matter.
27, you are appearing for the state. For the petitioner. Yes.
Led by learned advocate general this matter.
High Court administrator.
I for the High Court administration.
No, my lord,
No.
this case is, in a nutshell, that the petitioner was appointed in judicial service in 2000. Now, in 2016, a criminal proceeding was initiated against him. A criminal investigation was initiated against him, and while he was posted in Alipurdwar, and he was put under suspension as soon as the FIR was filed. And after this trial continued for, after investigation, trial continued for 3 years, and thereafter the petitioner was acquitted. Petitioner was acquitted from all charges. All the charges against him were not proved. Now, my lord, thereafter, as soon as the criminal proceeding was concluded, thereafter the state or the de facto complainant, they didn't prefer any appeal. So that finding of the trial court attained finality. A disciplinary proceeding was initiated against the petitioner in 2000. I'm sorry. 2020, my lord, by issuing a charge sheet. After the charge sheet was filed, the first date for the proceeding was fixed in 2023. It is after a gap of 3 years. Now, on 2023, no proceeding was held. Next date was fixed in 2024. Then also nothing.
Now, what is the stage of the proceeding now?
But stage of the proceeding is that. Yes, my lord.
The entire
Let me please. Please, I will. Let me. I'll try to.
Yes, what is the stage of the proceeding?
My lord, proceeding was supposed to end as per the order of the Honorable High Court on 23rd March 2025. That was the time limit fixed by the Honorable Division Bench. Now, that time has expired, no extension has been sought. So, as of today, in the eye of law, there is no proceeding, my lord. And my promotion has been withheld from 2016. I have been graded.
Why the proceeding has not been concluded within time?
It has been, Lordship, kindly take the trouble to consider page 98. The penultimate portion of the Honorable Division Bench order. The time was 4 weeks, and the inquiry report has been.
Page 19.
98.
98.
I have not received any inquiry report, ma'am.
The inquiry report has been done on 17th March 2025, and it has been placed, and it has been submitted, and it will be considered by the Honorable AC Committee. 27th, what I have heard, 27th November. Just now we have heard that 27th November is the date for the meeting.
My lord,
taking decision.
My lord, kindly see page 98, my lord. That clarifies everything. And I have not received any inquiry report, any communication whatsoever. কোন পেজটা রেফার করছো 98
Within 4 weeks from 24th of February 2025.
Just now I have received the information from the Department of Social. It has been completed 17th March.
My lord, kindly
And it has been placed down on basic.
The inquiry report was submitted on 17th March.
My lord, that is, I have not received any copy. And on
Because it has to be placed before the disciplinary authority.
my lord, kindly.
So before that, you are not entitled to get any copy.
My lord,
It
kindly.
may so happen that the disciplinary authority may not accept the inquiry report.
Yes, my lord, I fully appreciate. My lord, kindly see.
So where is the aberrations?
29th July 2025, I made a representation. Nothing was communicated to me. And my lord,
Because
even
it
if
has to be placed before the administrative committee.
my lord, even if on 27th it is placed, that is also a non-est in the eye of law in view of the latest Supreme Court judgment, my lord. In September, a Supreme Court judgment has come, authored by my lord Honorable Justice Dipankar Datta, where his lordship has categorically stated, distinguishing previous judgments on the same line, that when a date is fixed, if the disciplinary authority cannot conclude that within that date, it should have completed within 23rd of March.
It has been concluded.
27th. So far, my learned friend
No,
has said,
17th.
17th March. 27th.
my lord, but
17th March, it is within time.
I have not been communicated also that it is completed.
Question of communication does not arise unless and until it is formally accepted by the disciplinary authority.
So, my lord, I will restrict my prayer. I'll modify my prayer in this respect, and I may be given a copy of the communication my lord, my learned friend has relied on.
It may so happen that the disciplinary authority may not agree with the findings of the inquiry officer.
Absolutely. But my
You
lord,
will be
it is-
granted opportunity to respond to the inquiry report after it is formally accepted by the disciplinary authority.
Absolutely, I bow down, my lord. My lord, one just to show the conduct, my lord. Kindly, I'll.
No,
hand
at
up
this
the
stage, a
judgment.
court is not inclined to see this because it is within time. Let it be, because entire thing will become academic if the disciplinary authority does not accept the report.
My lord,
So therefore, it is fixed on if the disciplinary authority ultimately accepted or the administrative committee accepts the report, it will be sent to you. Then you will highlight the points which you want to agitate before the disciplinary authority.
My lord, but my lord, my promotions
But,
have been withheld.
expiring the time or the time has expired and the decision could not be taken or the inquiry report could not be furnished or prepared, that perhaps that point is not open to you in view of preparation of inquiry report on 17th March
17th,
2025.
my lord, I absolutely agree on that point, my lord. But my lord, there has to be an end of the proceeding and a definite timeline. My lord,
When
my
the
promotion is withheld.
administrative committee meeting is fixed.
27th November 2025. Today is 25th.
Very well. Today I am not, shall I dispose it off?
No, so
No,
with
my
the
lord,
direction to
my
take
lord,
the
my lord.
decision within a 4 weeks or 2 weeks, whatever your lordship felt. Because keeping
My lord,
this
let
in-
it
because
be.
your lordship has already opened your lordship's mind. If it is accepted, then one step. If it is not accepted, then it will have national debt.
I would rather, my lord, pray that let it be pending. Cyanidine, let it be pending, because I'll again have to file another writ petition. I'm sure of that, my lord.
So new cause of action.
Because
will
the way
arise.
the inquiry has proceeded,
Because
4
the
years.
very basis of your writ petition is failure on the part of the inquiry officer to prepare the inquiry report within time. That is not found to be the correct.
And my lord,
I will record the submission made on behalf of the High Court administration that the inquiry report was prepared on 17th March 2025.
Without communicating me, my lord, that because I am not aware.
Question of communicating at this stage does not arise.
My lord, I fully appreciate, but my writ petition is based on the premise that nothing has happened because I have no information. And my lord, in the meantime, I may be given provisional promotions, my lord. My promotion has been blocked for last 9 years, 6 years. Last 9 years, my promotion is blocked. I would have been district judge by now, or additional district judge at least by now.
as the bank. So during pendency, promotion does not arise. And your all prayer relates to promotion.
My lord, promotion, my lord.
How that is permissible at this stage?
My lord, what
It could have been permissible if there would have been abandonment of the proceedings.
My lord,
that has not been done.
I fully appreciate.
And that is the very basis of your writ
I
petition.
fully appreciate, my lord. That's why I'm not
So-
pressing it. But my lord, a timeline may be fixed.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner is in judicial service against whom a proceeding was initiated.
ইন্টারনাল নোট ভাই সেই জন্যই বলছি তুমি দেখে নাও ইন্টারনাল
আমি কোর্টের অর্ডার নিয়ে একটা কপি নিয়ে নিচ্ছি।
Against whom a disciplinary proceeding was initiated. Proceeding was initiated by the High Court administration. And it is contended by the learned advocate representing the petitioner that within the stipulated time as fixed by the Honorable Division Bench video order dated 18th February 2025, inquiry officer could not furnish inquiry report on concluding inquiry proceeding. Stop. It is further submitted that since the inquiry officer failed to conclude inquiry proceeding and prepared inquiry report within the time stipulated by the Honorable Division Bench in order dated 18th February 2025, petitioner needs to be promoted to the next higher cadre or to the next higher post, irrespective of outcome of the disciplinary proceeding initiated against him. Next paragraph. Mr. Day, learned senior advocate representing High Court administration, has submitted a writing of joint register within bracket GA, capital G, capital A, hyphen capital Roman 2 close bracket, dated 24th November 2025, and same is taken on record. From the said document dated 24th November 2025, it appears that inquiry officer submitted inquiry report on 17th March 2025 in connection with disciplinary proceeding initiated against the petitioner, and the issue is pending before the administrative committee for consideration. Next paragraph. On perusal of the order passed by the Honorable Division Bench on an intra-court appeal being MAT 2247 of 2024, within bracket Shambhu Sarkar versus the state of West Bengal and others, it is found, or it appears, that the petitioner, being the appellant in the said appeal, was directed to file written statement of defense on 24th February 2025, and thereafter inquiry officer was directed to proceed to record his findings and draw inquiry report and to place the same before the disciplinary authority within 4 weeks. Within 4 weeks to be reckoned from 24th February 2025. Stop. Next paragraph. As it appears from the writing, from the document dated 24th November 2025, which is placed on record today, that the inquiry officer submitted report on 17th March 2025. Therefore, it is found that within the time stipulated by the Honorable Division Bench in the order dated 18th February 2025, inquiry officer was able to prepare the report and submit the same before the disciplinary authority. Stop. Next paragraph. In view of the steps taken by the inquiry officer in terms of the order dated 18th February 2025, passed by the Honorable Division Bench, this court expects that necessary steps shall be taken by the disciplinary authority in accordance with law shortly. SHORTLY. Next paragraph. With the aforesaid observations, writ petition stands disposed of.
Kindly fix a time frame, my lord. Again, it will. I am deprived of promotion for last 9 years, my lord.
Wait.
Any time frame, my lord, as your lordship deems fit, my lord.
This is not your prayer in this writ petition. Your prayer is promotion due to abandonment of disciplinary procedure.
My lord. But that was.
He made some interesting points, but that has not been placed before your lordship. But an interesting point, that honorable acquittal, but subsequently judge issued.
Very well. So at this stage, court is not inclined to enter into those
Neither the
issues.
single bench nor the division bench.
Because the very basis of your writ petition is completely different.
Yes, ma'am. Yes,
You
ma'am.
proceeded on the premise that the inquiry officer failed to submit report.
Yes,
within
exactly. Exactly, my lord. Exactly.
Obliged to.
My lord.
Item number 28.
Here, in this case, the petitioner appeared the examination for the year 2025 for CAPA conducted by the SSC.
You are appearing for?
My lord, for Union of India, my lord.
This is my affidavit of service.
You have instruction?
My lord, today I have received the brief. Now let them submit, my lord.
Well, what happened in this case, my candidature was rejected on the ground of shortfall of height in PST stage. Well, I crossed the first hurdle and second hurdle also. Thereafter, the respondent authority rejected my candidature, initially page 18 of my writ application.
Page 18?
18, Annexure P3.
It is the order of the first authority.
First authority, PST.
168.7.
168.7. Thereafter, I approached before this honorable court. This honorable court was pleased to direct the respondent authority to constitute a board, and my appeal, that is the remeasurement of my height and chest, was considered and directed page 9.
Appeal was preferred against this order.
No, my lord, appeal was preferred of the order passed by the PST board through online. PST board Pass the order.
Physical standard test.
Standard test. That board, the page 18, the order passed.
That is the outcome of physical standard test 168.7.
Yes, that
Yes.
said challenge.
Against which appeal was
Appeal
preferred.
was preferred
Where is
to
the
all
order of the appellate authority?
Appellate authorities or the they have not considered my appeal. Then I approached before this honorable court. This honorable court was pleased to direct on September 25th, 2025 that my appeal should be considered within a stipulated period. That ordering portion is my lord, page 22. They have constituted in the meanwhile. What happened? They have published the result for selected candidate who has been called for detailed medical examination.
No, coordinate bench directed to take decision on the appeal.
Appeal.
What was the decision taken?
Yes, that the decision was taken. Kindly come to page 34. 34 is the admit card and 38 is the decision. Page 38. Required
169.5.
5.
Yes.
Already. Then the remarks is not qualified in height and chest. Chest also, my lord.
But if it is 169.5, then petitioner is entitled to get the benefit of clause 2D.
My lord, there are
your guidelines by rounding it off to the next higher centimeter.
Yes.
My lord, there are two issues are there. As it appears from this report, if your lordship
Yes.
kindly see,
Chest
there are two
also.
issues, height and chest.
Chest.
Now, chest, if your lordship kindly see, normal chest 80, obtain 83, and expanded chest 85, obtain 88. Now, there is a provision is that in the recruitment guidelines that chest measurement expanded up to 5. There is 80 is the minimum expansion is 5. So it should be 80 to 85.
In normal position, it should be up maximum up to 85.
80, normal 80.
Normal 80, it can be up to maximum
85. Grateful, my lord, grateful.
85.
Grateful.
And in expanded position, it can be up to 90.
No, my lord, the cutoff is 85. Subject to
in
correction.
normal position.
Yes.
And so far expanded position is concerned.
If your lordship kindly see page number 38, my lord. Page number 38 of this guidelines, my lord. Page number 38 of this.
So therefore, it is found that it is within range 83.1.
No. Unexpanded is 80 and minimum expansion 5. So it should be 80 to 85. Beyond 85, not qualified. If your lordship kindly see the guidelines, page 38 of this writ petition. My lord, point number 12.5.2.
Yes.
Chest male candidates should have the following standard of chest measurement: 12.5.1 unexpanded 80 and minimum expansion is 5 centimeters. So it should be 80.
So in expanded position, it must be, it can be up to 85, not beyond that.
Yes.
Here it is 88.1.
No, he exceeds that 85.
Yes, 80. Here it is 88.0.
88.0. He has exceeded that 85 point. Therefore, he has been.
So there is no relaxation clause.
No, my lord. In this case, there is no relaxation
clause 2D. I am paying for the benefit of clause 2D.
That is height and weight.
That was the example. In case of borderline. In case, yes, weight case or weight. In the case of weight measurement,
there is any specific provisions relating to a chest that can be taken care of, otherwise no.
Absolutely. Grateful, my lord.
No.
Yes, my lord. The requirement is the minimum chest measurement is 80 and the expansion is 5 centimeter. Minimum 5 centimeter. If I have more than 80 and more than 5 centimeter, then that is acceptable. It is not the case that I have not touched the minimum requirement of chest measurement. I have crossed. My lord, my minimum requirement is
expanded position. It can be considered up to 85.
Yes.
No.
Your expanded.
No, not up to 85. My lord, minimum expansion is 5 centimeter. It can be more than 5.
No. That is not the part.
Yes. That is the my lord, clause, and they require. They always accept that. Minimum requirement is 5 centimeter expansion. So, my lord,
chest male candidate should have the following standards of chest measurement.
Yes.
Unexpanded 80 centimeter.
Normal.
Minimum expansion
5
centimeter.
That is the wording is minimum. My lord, if expansion is, I can expand my chest more than 5 centimeter, it is acceptable. Minimum 5 centimeter expansion.
What is maximum expansion?
My lord, if your lordship kindly see that page 35, once, my lord.
38, come to page 38. What is maximum expansion?
My lord, our case is that it should be 80 to 85. Minimum normal 80 and expansion is 5 required.
That there is a case, so far petitioner is concerned, considering 12.5.2.2, it says that unexpanded 80 centimeter.
Yes.
In normal position, 80 centimeter.
Yes.
Petitioners normal chest in normal situation, petitioners chest is measured 80.
83.5.
83.5.
3.5.
Where it is unexpanded 80 centimeter is minimum 80 centimeter. If it is above 80, then the candidate will be qualified. If it is less than 80, candidate will be declared as disqualified. Similarly, in expanded situation, condition, minimum measurement would be
85.
85.
Yes, I have
If
crossed that.
it is less than 85, if it is on expansion, if it is 83, then petitioner would be declared as disqualified. If it is 85 or above that, then petitioner is qualified.
My humble
That is the
submission.
part of
My,
12.5.
if your lordship kindly see page 35, my lord, if your lordship kindly see, that is, my lord, the required, what is the required guidelines and what they have obtained. If your lordship kindly see that page 35, my lord.
If instead of minimum, the expression or connotation would have been used as maximum, against 12.2, 5.2.2 question would have been different. Then this court would have accepted your argument. But it is specifically the connotation is used minimum, which goes to show that minimum expansion is 5 centimeter, not less than that. If expansion measured is 85 or above 85, then petitioner is or candidate is required to be adjudged as eligible candidate. If it is less than 85, then disqualified.
No, this is the normal, my lord. Normal, it is required 80. And minimum
Do
expansion.
you want to take any instruction?
My lord.
My lord. Affidavit of service.
Yes, I have filed.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD in Central Armed Police Forces within bracket CAPFS close bracket on physical standard in physical standard test. Chest of the petitioner in normal normal condition or in normal in physical measurement test, normal or in physical standard test, normal chest of the petitioner was measured as 80 centimeter, 83.1 centimeter, whereas minimum requirement is 80 centimeter, and in expanded and expanded measurement of chest. And expanded chest measurement of the petitioner was found as 88.0, where minimum requirement is 88.0 centimeter, where minimum requirement is 85 centimeter. Stop. Relying upon 12.5. Relying upon clause 12.5.2 of the guidelines of the extent guidelines.
No, my lord, this is the notification, employment notification.
Oh. It is a where is the first page of this?
First page of notification, my lord, I have, but I could not, my lord. Excuse me, I can.
relying upon clause 12.5.2.
My lord, this is the notification, full volume.
Of the notice dated 5th September 2024. It is contended on behalf of the petitioner that as expanded chest of the petitioner was measured, eight 88.0 centimeter, and in normal position chest of the petitioner was measured 83.1. He should have been declared as fit as an eligible candidate for being appointed as Constable GD. Next paragraph, blind advocate representing Union of India has paid for accommodation to obtain instructions. Next paragraph, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 9th December 2020. Take it back. Next.
Item number 29.
My lord, yes, my lord, Advocate Bhudev Chatterjee is appearing for the petitioner. He unfortunately met with an accident, and as a result, I am praying for not this week.
Issue. At the time of call on behalf of the petitioner, accommodation is prayed for since the learned advocate met with an accident. Stop. You are for the state.
Union of India.
Union of India is represented by learned advocate. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 15 December 2025.
Much obliged.
Item number 30.
Affidavit of service, Your Lordship. Yeah. I am praying for non-payment of my terminal benefits. The petitioners are all retired employees of the Calcutta State Transport Corporation, and they are covered by the General Provident Fund scheme.
Court fee?
Lordship, one has been given, Your Lordship, during the course of the week.
No. It's learned advocate representing the petitioner is granted leave to deposit deficit court fees, as it is found that at the time of filing the writ petition, court fee in respect of one petitioner was deposited. Stop. Hearing of stop. List the matter. Hearing of this writ petition stands adjourned. List the matter under the same heading for further consideration on 3rd December 2025 in order to enable the learned advocate for the petitioner to take steps. The affidavit of service filed on behalf of the petitioners is taken on record. Next.
Item number 31.
31, may I please, Your Lordship? I am for the petitioner.
I am for the Union of India.
This is my affidavit of service. What happened in
We are for Union of India.
The petitioner appeared the examination for the driver of the CRPF. This examination conducted by the CRPF personnel for the driver. I appeared, I fill up the form. Thereafter, I called for the My lord, PST, PET, I passed. Then the trade test comes. The trade test. Trade means I am driver. I applied for driver. My driving will be test will be conducted. At the time of driving test, I just reached start the car, and then the officer asked me to come down from the car and hand up the rejection order. My lord, kindly come to page 25. Although, my lord, I have a heavy driving license and I am a regular driver. I drive the passenger vehicles of a company for last 3 years.
What is the LMV?
It will be light motor vehicles.
You are challenging this page 25.
Page 25. My lord, this is
But
the
no reason is given.
No reason is given. This is the
Yeah.
guideline for the trade test.
Lord, the paragraph 7 is his only point. Paragraph 7. I sent a mail.
Page 25 is under challenge. Now, not qualified in trade test driving of LMV.
LMV, light motor vehicle.
Page
Light motor
25,
vehicle.
that's the rejection. Yes.
Where is the reason in support of rejection? Mechanically, this order was passed in mechanical manner.
This is standard format is that. I have sent an email. I'm sent an email to them, but particularly the reasons for rejection. I have yet to receive the instruction. Then I'll see that.
But you cannot improve this order of rejection by subsequently supplying
No, Miller,
or adding reasons
Miller,
by obtaining instruction.
Miller, one thing is this that
1978 Supreme Court.
No, reason order is that the
Celebrated
test
judgment of the
test is taken. Test was taken.
By filing
He was
affidavit
no
or
question of
report, you cannot improve this order.
No.
Where are the reasons? Where are the reasons? Declaring a candidate
not
disqualified.
qualifying interest driving. Point is this that he just went to the driving positions and shifted the rear key. That was the technical point for them. But still, let me get the instruction from them. They reply why. This is the reasons. He
Let me set it aside. Takes pass an order, appropriate order.
Say, kindly give me 7 days time. I will give the answers.
Let me see what reasons come. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. In the writ petition, an order dated 12 November 2025 is questioned, whereby petitioner was declared not qualified. In trade test, it is called trade test. Trade test. While driving light motor vehicle within bracket LMV. Stop. Such test was conducted for recruitment in the post of driver in CRPF. In Central Reserve Police Force within bracket CRPF.
The examination is
Next paragraph. However, on perusal of the order dated 12 November 2025, it appears that the said order is bereft of reasons. Next paragraph. Learned advocate representing Union of India has prayed for accommodation to obtain instructions. Stop. Hearing of this matter stands urgent. List the matter under the same heading for further consideration on 2nd December 2025.
Instead of CRPF, it should be CISF.
CISF. Central Industrial Security Force. CISF. Central Industrial Security Force. CISF. CRPF not. Take it back. Take it back, Mr.
Much obliged.
Next matter, Thomas. Please call the list.
Item number 32.
Right, please, Your Lordship. My Lord, I am appearing on behalf of the petition in this matter. My Lord, before I make any submission, may be permitted to file my affidavit service. But what has actually happened in this case? The petitioner had been working as a head constable under the Railway Protection Force. But it is alleged that there was a theft in the cart shed of the railway, and in that period, he has been working as a head constable. Under him, there were 8 or 9 constables were there. But our case is that he has been falsely roped in. That case,
Falsely?
Yes, there was a criminal proceedings started against him and the others also. They all got bail. All got regular bail. There was no problem, or they were taken into custody, nothing of the sort. Thereafter, my Lord, a charge sheet has been issued in 2020. My Lord, departmental proceedings started, and my Lord, unfortunately or fortunately, I will not make any comment thereon. They moved the analogous application, all the 8-9 persons, they moved the analogous application. A writ application was moved before the learned single bench. I am not, my Lord, naming the judge. But his lordship was pleased to, that was a very rational order, in my opinion. His lordship was pleased to direct the authorities to file your affidavits. And there was a direction also that no final order will be passed without the leave of the court. But no stay was granted. But against that, analogous appeals were preferred before the Honorable Division Bench. The Honorable Division Bench, after having gone through all the papers and documents and considering the matters on record, was pleased to hold that departmental proceedings will continue, and that department would be entitled to, they may continue the proceedings, and the justice may exhaust all the remedies. The order of removal was passed against all the 8 or 9 persons, analogous order. I have annexed everything in my writ petition. But thereafter, that your lordship knows, my lord, that under the railways or in the paramilitary.
What you are praying for in this?
Lord, I am praying for this, my lord. This is a case of double jeopardy. I tell you, lordship, very shortly. My lord, the order of removal was passed against that the petitioner, this petitioner, preferred an appeal. Under the statutory rules, appeal is there. Then appeal was dismissed. Against that, they preferred the revisional application. The revisional authority, who is the highest body, having gone through all the papers of the inquiry report and the appeal court's appeals order, came to the findings that the findings of the appellate authority as well as of the inquiry report are not based on evidence, and thereafter he acquitted all of them. I'm not appearing on all of them. I'm appearing only for them.
What was the order? Part of the order?
Revisional order. May I please the revisional order, the final order. And he will not.
What was that order?
That order was that there is no materials against the petitioner, and he was directed to be reinstated in service. He was reinstated in service, and the other payments, that subsistence allowance, those things were not paid. But after some time, in the meantime, what has happened? He retired on 31st of August 2025, this gentleman. But on the very day of retirement, he has been served with another notice, a memo of charge, the second memo of charge, on the same ground, identical reasons, and his pensionary benefits have been withheld. He has not been paid a single penny, and that is the reason I have to come under the shelter of fellowship.
Show me the order of the revisional
authority, your lordship can see. That is very important. Lord, your lordship may kindly see the order of the audit. Revisional authority. Yes. Page 108, your lordship can see. Page 108, next page, Lord. Page 109. Order dated 1st of April 2025.
This is the order passed by the revisional authority.
Of the revisional authority. Lord, last page, may I read it. Perusal of memorandum of transaction dated 16th of December 2020 shows that this has not been followed. The rules has not been followed. Page 112, Your Lordship kindly come. Instead of asking Your Lordship to go through all the.
Just a minute. Yes, so in
Yes.
terms of this order, a fresh charge sheet
Yes.
really has been
Lord,
issued.
page
With the wrong in it.
Yeah, I'm coming.
This order was passed on 1st of April 2025.
Yes.
And charge sheet was issued in the month of August 2025.
In the meantime, I'm coming. Next page, Your Lordship kindly see.
Now, what is the present position? So for the
Page
proceeding,
120, Your Lordship kindly
second,
see for a
fresh
moment.
proceeding is concerned.
My Lord, subject to Lordship's place of blood.
Yes. What is the position? What is the present status of the proceeding?
We have issued the fresh charge sheet. Now, Lordship.
In the month of August 2025.
Just give me a Lordship.
When Your Lordship pleases to ask the question, Your Lordship may ask the question.
But I am told that the proceeding has already initiated and it's going on.
Not going on.
Inquiry is concluded.
No, not going on. It has only a notice has been given. My learned friend does not have the proper instruction. A notice has only been given. Nothing has proceeded further. But before that, my learned friend makes a
Very well, let me direct the authority to conclude the proceedings within certain time.
Lord, one thing Your Lordship kindly notice. Page 120, Your Lordship kindly see for a moment. Oh, 1 minute, Your Lordship kindly see. For my sake, page 120. I'm putting this question to myself under what provision they can start the second de novo proceeding on the same identical grounds. There are several judgments of the Honorable Supreme Court on this point that you cannot do that. Page 120, Your Lordship, kindly see for a moment. I was given this notice. I joined the service. I was asked to go for the medical test. I went through the medical test. The medical test was found correct, and I have retired on 31st of August 2025. And before retirement, my learned friend must be knowing that under the railway service pension rules, all papers are to be prepared at least 6 months before the retirement. Nothing has been done, and everything has been kept in limbo. That is the problem, and I have not been given even the provisional pension. Where is the law that I will not be given the provisional pension, even if suppose a disciplinary proceedings is started, or I have retired, or departmental proceedings are continued? The law is very clear on this point. May I place the entire circular? That will be a time-taking thing. My learned friends should also know this.
Under what
Under what provisions they can?
Where are the decisions that once the proceeding is found to be erroneous, so from that stage it cannot be initiated again.
On this, not on if
That is
materials,
the very principle enunciated by the Supreme Court in very many judgments.
May I humbly subject to Lordship's pleasure. Give me some time. I am placing one circular. Grant of 10% provisional pension under Rule 69.
Provisional pension will come later on. But regarding initiation of disciplinary proceedings based on charge sheet, please allow this court based on charge sheet dated August 2025. As per leave granted by the revision authority, where is the bar?
May I submit one thing? May I sum up in this way? Let them file the affidavit. Your Lordship may direct that yes, departmental proceedings may be concluded within a certain stipulated time. But I cannot be deprived of my interim.
Let me direct the authority to conclude the proceedings by 6 months.
And I should be paid by provisional
why
pension.
petitioner is not getting provisional pension?
I'm not getting the provisional pension. May I read it?
Because of the pendency of this proceeding.
But provisional pension should be paid.
And may it be Your Lordship further direct the
show me the provision that provisional pension cannot be. What is your rule? What is the relevant provision relating to release of terminal benefits or provisional pension in view considering pendency of the proceeding? Why? Where is the rule?
In that case, Lordship kindly gives us some time and we shall come up with
judgment
on this point only. And so far the proceeding is concerned.
Because in other service rules, you will find that when on the date of retirement, if disciplinary proceeding or criminal proceeding is pending against the incumbent or the employee, in that event, subject to final outcome of criminal proceeding vis-a-vis disciplinary proceeding, the employee is entitled to get provisional pension.
Much obliged, Lordship.
Lordship kindly gives us some time. We shall come back with the definite instruction on this.
And provident fund.
Provident fund
is his money. Why it has not been paid? Have you paid the provident fund amount to the petitioner?
Nothing. Not a single penny.
There is no. There should not be any bar relating to release of provident fund and the provisional pension.
And people have also not been
to take the proceedings to its logical conclusion.
August, September,
within
October,
certain
November.
time. But if by issuing a charge sheet indefinitely the proceeding is kept pending, petitioner should not be made to suffer.
4 months I am without pay. My family is suffering.
So by this time, hurriedly you should have initiated the proceedings by conducting inquiry proceedings, whether the inquiry is complete.
Not it. Notice only given.
A retired person. Your first charge sheet was faulty, as it was observed by the
That is the
revisional
finding of
authority.
the revisional authority.
Revisional authority permitting the disciplinary authority to initiate fresh proceedings by issuing charge sheet. But that does not mean that he will harass the petitioner in such a manner.
So kindly allow me to come back next week. I shall come up with all these instructions, whether his terminal benefits have been released or not, and what is the status of
On
the pension.
oath, I am saying not paid.
Sorry,
No, on oath, I am saying.
That is why court is asking.
Yes, my lord.
I will come up with full instruction regarding all these issues and
And if it is not paid, you have to demonstrate before this court that at this stage employer is not supposed to release provisional pension
and on what
based on rules. Otherwise, provisional pension and provident fund, these are required to be released in favor of the petitioner. Burial gratuity you may not pay, but so far other benefits. Suppose this proceeding continues for 3 years. So petitioner will die in the meantime. Issue. From the submissions made on behalf of the petitioner and Railway of Eastern Railway, Eastern Railway, it appears that have you annexed the second charge sheet?
Yes, Lord.
Where is that?
The second memo of charges. I have an explanation. Page, last page. Page 120. I have an explanation. Yes. Page 122.
129.
22.
22. হ্যাঁ কি বলছিলাম? It appears that based on second charge sheet dated 20 August 2025, disciplinary proceeding is initiated against the petitioner in terms of the leave granted PD order dated 1st April 2025. Passed by the revisional authority. Stop. Next paragraph. However, learned advocate representing Eastern Railway has prayed for accommodation to apprise this court on present stage of the proceeding, which is initiated after issuance of charge sheet dated 20th August 2025. Stop. On the next date, Eastern Railway is also required to clarify as to why till date Provident Fund and provisional pension have not been released in favor of the petitioner. Since petitioner retired on superannuation on 31st August 2025. Stop. Hearing of this next paragraph lists the matter under the same heading for further consideration on 2nd December 2025.
In the meantime, they will not proceed with the departmental proceedings. Otherwise, they may because
that I should
very well, my lord.
At this stage,
As your lord. Good sense will prevail upon him. নামটা দিয়ে দাও। Much obliged. আমাদের আরেকটা কথা আছে।
Item number 33.
But the petitioner might not have copy of the petition upon the concerned respondent. Pray for gratuity, interest on gratuity and leave salary matter. Your lordship passed on several orders.
Dugapur projects.
My lord already passed an order.
On revised benefit?
No. This is on principal gratuity and leave salary. Petitioner retired on 31st July.
Just a minute. You have let me go through my own order. When petitioner retired?
31st July 2023.
Yes. At page 13.
November 2024, it was paid.
LAC.
We have issued 17 November.
নাম দেওয়া আছে।
Yes, same order. এই এক মিনিট অর্ডারটা ও কারেকশন করে দিয়ে উনি কারেকশন করে দিয়েছেন ঠিকই আছে, এখানে একটা অর্ডারস হবে বুঝলেন। নেক্সট
Next one also same, not
item
revised.
number
not-
34. Not on revised as per RUPA 2020. Retired on 30th June 2023.
Yes.
And the amount was 17,57,392.
Yes.
And it was paid on
12/11/2024.
12 November 2024.
No, 9.
Same order.
Yes.
Grateful.
Item number 35.
Is the affidavit of promise. Deficit court fees have been paid.
My lord, Mr. Lahiri is appearing on behalf of Mr. Siddhartha Lahiri. Is appearing on behalf of the respondents. He's on leaks before court number 28. Kindly.
Not today. Take back your affidavit of service. Not today.
Item number 36.
Lordship, my senior is very sick today, so no, please.
Who is your senior?
Shamik Chatterjee. Yes.
He has not come to court.
Yes. He's
When
very
he will
sick.
come again?
From tomorrow.
He is sick today. He will be fit tomorrow.
He's sick for 2 days.
Only for 2 days.
Yes.
How do you know that tomorrow he will be fit to attend the court?
Please fix on whichever my lord is, Yeah.
Miss Alam, not today.
My lordship, not today.
Thank you, my lord.
Item number 37.
Lordship, in this matter, I'm led by Mr. Shamunath Rai. He is in courtroom number 40. He just went. I'm just praying for not today.
In this matter, I am appealing on behalf of Union of India, but I am paying at least 2 weeks time to get instruction.
2 weeks instruction.
But
What is the matter about? That you require 2 weeks time to take instruction?
Railway service block. Yesterday, I contacted the concerned party.
Service, what is claimed in the writ petition?
The retirement benefits.
And for that 2 weeks, retirement benefit, what will happen to the poor petitioner?
At least one.
Very good. Issue. At the time of call, accommodation is paid for on behalf of the petitioner. However, learned advocate representing which authority? Railway authority?
Yes.
However, learned advocate representing
I am appealing on behalf of one.
Eastern Railway.
Eastern Railway, yes, Lord. Respond number 1 to.
However,
There is
learned
also
advocate
private
representing Eastern
We have served upon the private respondent.
Eastern Railway has paid for accommodation to obtain instruction. Stop. Next one, list the hearing of this matter stands urgent. List the matter under the same heading for further consideration on 3rd December 2025.
Yes.
Item number 38.
My lord, am I paying for the petition? Your lordship, this matter relates to non-payment of my terminal benefits. The petitioner retired from service on 31st of October 2023 from Calcutta State Transport Corporation, your lordship. He has
31st October
2023 from Calcutta State Transport Corporation.
Yes.
He has been paid 20% of his provident fund on 24th of November 2023. Lordship, to an amount of rupees 7,07,000 to your lordship.
20%.
20%. 80% of PF. And that is CPF. He's under CPF. So your lordship, 80% provident fund has not been paid, and he has been paid the gratuity in 2 installments and leave salary 1. So in different dates on delayed.
Still 80% contributing provident fund is left to be paid.
Left to be paid.
So what is your prayer?
My prayer is to disburse 80% of my provident fund with interest and the interest on the delayed payment of my gratuity and leave salary.
Yes.
Lordship, I have the order. If my lord, Judge Sahib ke debe na order ta.
কি অর্ডার দিচ্ছি অ্যাকাউন্ট কি অর্ডার
ওই যে যেটা জাস্ট অনিরুদ্ধ রয়ের কোর্টে ছিল, এই যে এই অর্ডারটা দিয়েছি, সেম অর্ডার।
কি মামলা
ওই জাস্ট অনিরুদ্ধ রয় অর্ডার যেটা ছিল।
কি মামলা এটা
এই 80% পিএফ দেয়নি ওটা।
আমি তো বিয়ে করছি
তুমি তো করছো দাদা, কে করছে না?
তুমি কি সাথে গায়ে জ্বালানি আজকে করলে?
একদম না, ভালো কথা, তুমি মাঝে মাঝে তো সাপোর্ট করো আমাকে।
কোন পার্টি করে কি কারো
স্টেট
বেশ করে
It was practically same.
80%, 20%. Amount গুলো change
Amount তো change হবে।
Same.
Order.
Yes, let the same order be passed. A 20% provident fund was paid and leave salary was paid,
Leave salary, gratuity also paid.
but it was delayed payment.
Lordship, gratuity and leave salary delayed and
Gratuity and leave salary was paid in its entirety.
Not only one thing, not on the merits. If she is relying on this order, then in the prayer she should have asked for 8%. Why is she asking for 10%? Lordship, dismiss it.
no. Lordship, 6%, your Lordship, I'm not in dispute 6%, but if it is not paid within 3 months, if they paid in 3 months, so
If she's relying on it, she should rely in toto. Then why should she?
Default Lordship. In future, your Lordship, I will.
Affidavit of service filed on behalf of the petitioner is taken on record.
আমি এরকমই থাকি
Petitioner
তুমি পুরো রিলাই করলে পুরোটা চাইতে হবে 10%
was an employee of Calcutta State Transport Corporation who retired on superannuation on 31st October 2023. Stop. It is submitted by the learned advocate representing the petitioner that petitioner was under contributory provident fund scheme and after retirement 20% of provident fund dues or provident fund due was paid to the petitioner belatedly. Stop. Likewise, leave salary and gratuity was also paid to the petitioner. Not on the date of retirement, but subsequently. Stop. Petitioner has made twofold prayer, comma, payment of 80% provident fund, payment of 80% provident fund dues and interest on retirement dues due to delayed payment. Next paragraph. Calcutta State Transport Corporation and the state respondents are represented by learned advocates. Stop. Next paragraph. Having considered the case made out in this writ petition, court finds it apt to direct the concerned authority of Calcutta State Transport Corporation to release or to pay 80% of the 80% of unpaid provident fund dues to the petitioner by 6 weeks from the date of communication of this order. Stop. Since it is found that concerned respondent authority caused delay in releasing retirement dues, comma, state authority is directed to pay interest at the rate of 6% per annum on leave salary, comma, gratuity, and unpaid provident fund dues for the period from unpaid provident fund dues from the date following the date of respective payments till the date of release of the said amount within a period of 3 months from the date of communication of this order. Stop. In the event concerned authority of Calcutta State Transport Corporation fails to pay unpaid provident fund dues and interest on retirement dues in terms of the aforesaid directions, respondent authorities in terms of the aforesaid directions within the stipulated time, respondent authorities shall be required to pay 10% interest on the shall be required to pay 10% interest on deferred payments.
I'm grateful, Your Lordship.
Yes.
The interest in case of default was, my lord, in all the orders limited at 8%.
Period 8%. 8%.
টাকাও পাচ্ছি, ক্যান্সেল করছিস কেন?
I'm grateful, Your Lordship.
Item number 39.
My lord, the Lahiri is still not here. Item number 39, 40, and 41. Kindly make it not today.
Mr. Lahiri is appearing not today.
Item number 40.
40, my lord, same, my lord. 40 and 41.
Same. Who is appearing for the Union of India?
Mr. Lahiri.
Where is he?
He's at court number 28. There's a fixed matter.
Appointment of Constable GD.
Constable GD.
Height or chest or weight?
Only height. Only height.
Not today.
Forty-one.
41.
42. Item number 42.
Lordship, I have been instructed to appear on behalf of respondent number 226, Eastern Coalfield Limited, today morning by phone. The brief is yet to receive. So I kindly pray to accommodate some time, Your Lordship.
You are appearing for ECL?
Yes, respondent number 226.
Issue.
And I'm filing the affidavit.
Affidavit of service filed on behalf of the petitioner is taken on record. On behalf of Eastern Coalfields Limited, accommodation is prayed for in order to obtain instructions. Stop. However, Union of India is represented by learned advocate. Stop. Hearing of this matter stands adjourned. Adjourned. List the matter under the same heading for further consideration on 4th December 2020.
Grateful.
Item number 43.
Your Lordship, the service has still not yet been done. So I have
Why it is stated in the presentation form that matter is to be listed on on a particular date on 24th November. If your service is not done,
due
in
to-
my previous determination, I used to direct the matter to appear in the combined list, monthly combined list, because I follow the procedure that in terms of the presentation form, matter will come before me under the heading motion.
Actually,
In
Lordship,
your presentation form, it is stated that to be listed on 24th November.
the senior advocate, Mr.
Who
Pradeep
will
Kumar
be the
Agar
senior advocate?
was
It is not the
hospitalized.
job of a senior advocate. It is job of the learned advocate on record. So if it is not possible for him after filing the writ petition on 18 November 2025 to complete the service by 24th of November, why in the presentation form it is stated that matter to be listed on 24th of November?
Apology, Lordship. Just one more day, you can list the matter on Friday. Everything is done. It needs to be just served.
So, at the time of call, accommodation is paid for on behalf of the petitioner since service is not complete. Stop. Next paragraph. Learned advocate for the petitioner is directed to complete service of notice upon all the respondents and file affidavit of service of notice upon all the respondents by 10 days from date and file affidavit of service on the next date. Next paragraph, list the matter under the heading motion in the monthly combined list of December 2025. Next.
Item number 44.
44, my lord, I am appealing for the petition.
For the statement.
Yes.
My lord, here I am challenging the gradation list which has been published by the district judge Paschim Bardhaman. That is page 70 onwards. And 79 is my only grievance against the district judge Paschim Bardhaman, wherein my date of appointment in the present post. So
You are doing all the matters of court staff nowadays.
now some matter.
Yes. Now it is there under the district judge Shiva Bardhaman. Paschim Bardhaman, yes. Who is appearing on behalf of the High Court administration. And district judge Bardhaman, you are for the state. Yes. Have you served upon district judge Bardhaman? Service is complete?
Yes.
Yes.
My lord, page 70 is the my lord gradation list which has been published by the Paschim Bardhaman. And
Page 70.
Page 70, 70. Without hearing any objection, first draft.
Just a minute. Annexure P10.
Annex and P10.
It's an order, it's not a gradation list as it appears.
My lord, by way of order, gradation list has been published. And page 79.
Now you are challenging this gradation
Yes,
list.
yes.
On what ground?
My lord, they are Paschim Bardhaman district judge Paschim Bardhaman. In gradation list, my date of appointment in the present post has been shown that on 10th 8/2022.
Where?
My lord, that is page 79.
79.
79.
Serial number 2.
79, serial number 2.
Page 79, serial
number 2. Malad
Yes.
Solil Roy.
Yes.
Last Malad date of appointment in the present post, that is on 10/8/2022. Present post means Malad, now I am process server.
Date of appointment 10 September 2012 as Group D.
Group D. Then
Date of appointment in the present post
post 10/8/2022.
10th August 2022. Yes.
As a process server. Malad, if your lordship kindly see page 21, when my promotion has been given.
Page 21.
21. 22.
Just a minute. Page 21.
21. That is the promotional order. And page 22, my name appeared as serial number 1.
10 September 2018.
18. And for that reason, my lord, I am not entitled, they are not giving my name as a UDC. They are showing my date of appointment.
Is there any avenue for further promotion?
Yes, my lord, I annexed 5140. That is page
So
23.
if your date of promotion
Yes.
to the post of process server would have been reckoned as 10th of September 2018 instead of 10th August 2022, then how you would have been benefited?
Now, in this way, my lord, now I am entitled to get promotion as UDC.
Considering your date of
Yes.
promotion as process server on 10th September 2018.
18.
Yes, why this has been done? You are the High Court. Yes. District judge has been served. So let me direct the district judge to remain present before me after 7 days at 10:30, leaving aside all other work. Represented, but nobody is represented. Show me that how you have served. Because it has been prepared by district judge Paschim Bardhaman.
Whereas, hearing the objections of the petitioner, that has reflected in the order that while preparation of this gradation list, all the objections were considered.
Taken into consideration. So there may be some explanation which can be offered by the district judge, but if the district judge is not represented, then it's difficult to adjudicate the issue.
We can intimate the district judge about this.
देखिए 21st November.
21st November.
Today we are on 25th. Viral, you inform the district judge to be represented before this court on the next date. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. In spite of service of notice upon the respondents, Promotional and Gradation Committee, Paschim Bardhaman, is also headed by district judge.
Yes, district judge.
District Judge Paschim Bardhaman and District Judge Paschim Bardhaman and Promotional and Gradation Committee Paschim Bardhaman, being respondent numbers 3 and 4, are not represented. Stop. Next paragraph. It is submitted by the learned advocate representing the petitioner in reference to a document at page 79 of the writ petition that the petitioner was promoted to the post of promoted to the post of process server on 10th September 2018, but in the gradation list prepared by the District Judge Paschim Bardhaman on 16th June 2025, date of such promotion was considered as 10th August 2022, not 10th September 2018. Stop. It is submitted that due to wrong date is mentioned against date of promotion of the petitioner. Petitioner, he is prejudiced. Stop. Having considered the grievance ventilated in this writ petition, court finds it now. Court desires to hear District Judge Paschim Bardhaman being respondent number 3. Next paragraph. Your full name? Debashish Banerjee. Mr. Debashish Banerjee, learned advocate, is representing High Court administration, who has prayed for accommodation in order to inform the who has prayed for accommodation which would enable him to inform which would enable the High Court administration to inform District Judge Paschim Bardhaman to be represented before this court on the next date. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 4th December 2025.
Grateful.
Grateful.
Item number 45.
Union of India, other respondent.
Below you have served all the respondent because the Union of India are the only respondent.
Yes.
Only all the the respondent authorities are the Union of India and this the instrumentalities.
Yes.
Challenging the propriety of the order passed by the disciplinary authority, affirmed by the appellate authority and the revisional authority, this writ petition has been filed. Prior to placing the just in a nutshell, I am placing the fact. Petitioner before your lordship was the sub-inspector and he was discharging his obligation as a camp in charge in the Bankhola area, in the CISF, Sitolpur Bankhola area. While he was discharging his obligations, he has been posted 2-3 years back. While he was posted, he used to form a team for conducting the raid in that areas because there was a consistent allegation that there was a pilferage of the coal. During his entire tenure and different financial year, substantial amount of the coal has been seized. For each and every month, substantial amount of the coal has been seized. Someone is 88 someone is 89, like this way, metric ton. And when the incident happened, then he conducted a raid. While he conducted a raid, he found that there was a pilferage stolen coal. So that has been seized. Along with an electronic weighting machine was seized. On the day that was on the 8th, that was on the 8th March 2022. 8th March 2022. On that day, as per the procedure established by law, he, after seizing operation, because he constituted a team, he led by the team. He, already entered the seized coal to the ECL, depositing the coal. And subsequently, so far as the machine is concerned, electronic weighting machine is concerned, that cannot be received by the ECL authority. So what he did, he went to the office of the local police station along with his team to handing over the said machine on the basis of the proper seizure list. They refused to accept it, saying that since no PS case has been started and therefore we are not seize it on the basis of only on the basis of your request. He came back. Then he went to the authority, to the security manager of the ECL. And he approached. On that day, he left out. On the particular day, 8th of March, in the evening, he left out. And on the official who have been deputed over there, he talked with the senior officer. He asked him to come tomorrow. On the morning on 9th of March 2022, he went over there and handed over the electronic machine, weighting machine, and proper seizure list has been given to him. And everything has been finished, and subsequently on the basis of which he wrote a letter in few days later, he wrote a letter addressed to the security officer that you have received a call not on that day and subsequently on a different dates. So you give me a receipt on that. And he issued the receipt also. But he is not right now, he is not finding that receipt where he has kept. So since that has not been escalated anything, and therefore that matter has been dropped. Subsequently, after few days, for the month of May 2022, there was a imputation of the charges. An article of charges has been leveled against him. What was the contention of the charges? That
so proceeding has been disciplinary.
Proceeding has been initiated by initiation of.
What is the present stage of the proceeding?
Proceeding has come to an end by invocation of the Rule 37. Rule 37 says there was a procedure that you can conduct a detailed inquiry or you cannot conduct a detailed inquiry. It depends upon the disciplinary authority. So they have chosen not to conduct a disciplinary authority. But what they did, just opportunity was given to me. I wrote certain the document and my defense in Hindi vernacular. Along with I deposited my few documents which are readily available, on the basis of which they have passed a final order, deducting one of my increment. Subsequently, challenging the propriety of that final order, I preferred an appeal. Appellate authority affirmed the said order, and then the revision I have filed, the revision authority also affirmed the passed by the appellate authority's order, and vis-a-vis the order passed by the disciplinary authority.
So you have come challenging the order of the disciplinary authority, then appellate authority, division authority.
My lord.
So there is no scope for passing any interim order at this stage.
My lord, I think that I would be, my lord, I think that I would be, my lord, impress your lordship, my lord, if I see it apparent from the document itself that this order is not sustainable, and if they intend to do a de novo inquiry, in that event they can done.
Yes, what is the ground of such challenge that it is not sustainable?
At the time of furnishing the document, I have given two documents that I have already handed over the coal to the ECL authority, and at the same time, so far as the electronic machine is concerned, I have handed over. The document has been given to me. So only one day single delay. That they are telling that my intention is to keep that waiting machine in my custody. It is their allegations. To ascertain the veracity of the matter, I would not be the appropriate person. My person, by whom we have been accompanied, they are the appropriate person. They will tell the actual fact, not the I. Because I was the leader of the team. According to my behest, the team was proceeded with. Neither of any person has been examined. Neither the my lord, in my statement of defense, what I have stated, that has not been examined. They did not go to the police station. Even they did not examine the my lord, the security officer also, who was not present on the relevant point of time. So on the basis of the my lord, the summary procedure, I cannot be punished, since they are themselves saying in the revisional order and the my lord, the appellate order that I could not produce any my lord, the document. I have already produced the document that the my lord, I have handed over the coal to the authority. They have seized it, and the seizure list is there.
No, in order to highlight that that this order of the disciplinary authority is erroneous, you have to point out the defects in the order of the disciplinary authority first.
Yes, kindly have a look at me. Correct, absolutely correct.
Where is the order of the disciplinary authority?
Page, my lord, 30, no, 33.
43.
33.
This is a chart. Final order.
Yes, lord. My lord, I am not placing the my lord, the article of charges.
That is set out.
Set out, yes. My lord, kindly take the relevant portion which has been set out from my lord, the defense, which
Paragraph
have
3.
My lord, paragraph 3, my lord. In force number such and such, the sub-inspector work Vishnu Prasad Behra and the received the above memorandum dated 8th of May 2022 and the submitted his written representation against it within the stipulated
Where from
time.
you are reading paragraph 3?
0.2, my lord. Page 33.
34.
33. Page 33, my lord, last paragraph. On force number such and such memorandum dated such and such submitted with the written representation against it within the stipulated time period on the 14th of May 2022, in which he has mainly mentioned the following points in his defense. On 8th of March 2022, during a raid, the outskirt of the SKF camp in the Ichapur such and such coal was seized by the ECL management. He surrendered the illegal coal to the ECL management and took the waiting machine to the Ukra police station, where they refused to accept the seized waiting machine, stating that it did not fall under their jurisdiction. ECL security in charge Mohammed Sach and Sach told me to return the waiting machine to the next day. Because Mr. Sach and Sach was away, the next day I returned the waiting machine to the ECL management and received a proper receipt. He felt that then this was not a big incident, but he should inform the superior, and he submitted the waiting machine to the ECL management with the proper receipt, and though it appropriate to inform only the ECL management. If he had any intention to mislead the department, he would not have submitted it to the ECL management, whereas he has submitted the waiting machine to the ECL management with the proper receipt. He had no ill intention to this. During his entire service period, he has followed all the orders given by the department and has performed his duties with honesty and integrity due such and has not been punished with such and such. Finally, he has stated that the allegation level
Written representation, yes.
Yes. So, my lord, the contention in the defense which has been taken, that the two documents which I have already received and I have surrendered, that has already been produced. But in reply to their, my lord.
Where is the finding?
Yes, finding is, my lord, I am pressing. The undersigned, after careful studying in all the documents and the available of the case file and the reply submitted by the accused force member, found that the reply submitted by the accused force member is not a satisfactory because on 8th of March 2023, during the raid on the outskirts of the SKP camp, the accused force member had seized an electronic voting machine which was kept in his camp premises instead of immediately depositing it to the nearest police station. When the situation, so my lord, it is their observation, then I am coming. When the situation worsened, the said machine was deposited to the ECL security to hush up the matter. The accused post member and the did not immediately inform the higher official about this and deliberately concealed the said fact from the department.
This is an appreciation of fact is required.
Correct.
So on the first day, this order cannot be set aside. Because everything depends upon appreciation of fact. Unless and until an opportunity is granted to them to file an affidavit, how these facts can be appreciated?
May I be permitted to place rule 37 once?
Whatever may be, but it depends upon deposition of weighing machine. If the weighing machine was not deposited at the correct place at correct time, as you are saying that you deposited it with the security officer ECL on the next date, as the police refused to accept the same. Now, they may say by filing an affidavit, they may dispute these facts. So therefore, an opportunity of filing an affidavit needs to be given. On the first day, hearing you, if I set aside the order without granting them opportunity to respond to this writ petition, that will not be the correct approach. Try to appreciate, because everything depends upon whether you have correctly deposited the weighing machine with the authority, or there was a departure on your part at the time of handling the weighing machine, whether you could have deposited it with the police authority, or police authority at all refused it or not. So in order to appreciate this fact, affidavit is required to be submitted.
Absolutely correct. I am not delaying the process. Only the thing is this.
And it's a case of stoppage of increment. Ultimately, if the writ petition survives and writ petition is allowed, you will get the benefit.
Your lordship knows, my lord,
Yes,
it is quite difficult, my lord. If your lordship gives
that's true, but at the same time, on the first date, it is not appropriate to.
Can it be that the he will file the report in
No, I do not follow this unless in exceptional cases.
May it be permitted to your lordship to
Where is the order of the appellate authority and
appellate authority, page 30.
Page 37.
No, my lord, 41. Typed copy, my lord, 41.
Everything cannot be sorted out by filing a report. Page 41 and
52. And below 49.
49, revisional authorities order.
Just a minute, below. Yes. 49. English version, my lord.
Page 49.
49.
English version. 15th May 2023, order of the revisional authority.
My lord.
Affidavit of service filed on behalf of the petitioner is taken on record. In the writ petition, final order of punishment dated 7th July 2022, and the order of orders of appellate authority and revisional authority dated 25th August 2022 and 15th of May 2023 are questioned on certain facts which are described or which are narrated by the learned advocate representing the petitioner. Stop. According to the petitioner, since the relevant facts were not appropriately appreciated by the discipline authority, an order was passed on 7th July 2022, which is adverse to the interest of the petitioner. Stop. Appellate authority and revisional authority in their turn affirm the order of the discipline authority. Next paragraph. Union of India is you are representing all the respondents. Union of India our respondents are represented by learned advocate who has prayed for accommodation to file, who has prayed for opportunity to file affidavit in opposition. Stop. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Affidavit in reply thereto, if any, be filed by 2 weeks, after ensuing Christmas vacation. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
Milord, one line submission may kindly be recorded that unless the detailed inquiry would be conducted, Milord, the appreciation of fact cannot be done.
It is my submission. At the time of final.
Milord, kindly fix a date, Milord, if your lordship.
By 4 weeks. 4 weeks.
Great. Item number 46.
Sorry. My lord, item number 46, I beg to appear on behalf of the petitioner. Let the affidavit of service be kept with the record. No, my lord, the petitioner before your lordship participated in the selection process conducted for engagement of constables in general duty. And now, my lord, what happened is initially they were rejected on the ground that they have not attained their height.
Participated for the post of constable GD.
Yes. Yes.
Yes.
Now, my lord, in the first round, what happened after the completion of the computer-based test, they come for the physical measurement test, where they were declared unfit because of they have not attained their height. Now, my lord, they approached this honorable court because there was no appeal preferred, because there is a provision of preferring an appeal on the same date. They couldn't prefer that. The honorable court was kind enough to grant them an opportunity to carry forward their grievances. And my lord, subsequently what happened, they communicated the order and the authority called them for a remeasurement. And in the remeasurement, my lord, they have attained an height which is beyond 169.5. Now, my lord, at this stage, your lordship, my lord, I will show to your lordship, the appeal says that there cannot be a second appeal after, my lord, a remeasurement. So, my lord, I say that I am entitled for the rounding off that is granted in the rules. That is, yes, that is my respectful submission.
Where is the order of the authority which was passed in terms of the order passed by the coordinate bench?
My lord, I'll take your lordship. My lord, I have annexed it. The
page 20, 169.2.
My lord, that was the first rejection. Thereafter, my lord, the honorable court's order is at page 24. Subsequently, my lord, I was called, that is at page 26, where your lordship will find the writ petition.
Page 26.
Yes. Immediately after the writ petition's order, my lord, there is this page 26. We have called, and subsequently at page 27, your lordship will find that they have noted that required height is 170 and I have received 169.8. Now, in my respectful submission, now, my lord, I am entitled for the benefit of rounding off because it is the second measurement. My lord, I will not proceed any further. This is my only, my lord, submission.
Yes.
Lordship, I really can't agree to my learned friend's contention that it can be rounded off. After all, Lordship, the height was what was given in the advertisement 170.
Yes.
The height was the requisite stipulation in the advertisement itself. In the advertisement for recruitment. That had very clearly.
No, where in the guideline there is a provision of rounding off.
Whether it is for height, Lordship, I've just received a brief.
I'll show you. This is
Whether it's for height.
May 2015 guidelines.
May 20.
Come to 2D. Please give me the guidelines.
Madam.
It's a revised guideline of May 20, come to pay.
2015.
Yes, come to 2D, Miss Alam.
Lordship, subparagraph B.
D, 2D, general instructions for recruitment.
Yes,
post.
Lordship sees
Then
measurement.
come to 2D,
Lordship,
borderline
2D.
case. In borderline case, last five lines.
Lordship, in a borderline case of overweight, BMI should be considered to arrive at conclusion, and variation of 5 kgs from the maximum minimum limit may be accepted. Similarly, while measuring height, fraction of centimeters less than 0.5 will be ignored, and 0.5 centimeters and more will be rounded up to the next higher centimeter.
Yes.
Standard weight chart, yes, Lordship. Then, of course, there is not.
What about chest measurement?
Chest measurement, my lord, admittedly I have qualified.
It is 80, 85.
80.
Expanded 85 minimum and 80 in normal position, 80 is the minimum.
Yes, my lord, kindly takes up
measurement,
page
where it is 84.6 and 93.9.
93.9.
So therefore chest, so far chest is concerned, there is
No, he's disqualified in
only height.
That is
That is your instruction also.
Lordship, I don't have instructions today. Should I just seek
We will
today's
come back.
time? I've just got the brief. I don't have instructions.
In the morning also, I have allowed a writ petition on instruction. No. If there are certain other reasons, you obtain instruction, come back after 7 days. That is it only the case of height, or for other reasons, petitioner has been declared disqualified.
My lord, only one my lord, humble request, if I may make, my lord, before my learned senior friend, that my lord, the medical test, my lord, we found out the 9th happens to be the last date. The medical test is ongoing, the second round after the physical test is over. So, my lord, that last date is 9th. If, my lord, instead of, yes, my lord, if a short time is given.
Subject to your lordship's convenience.
Yes, absolutely, my lord. That we both bow down, my lord, if your lordship.
Well, Monday at the top.
Monday,
Since it is similar case, I have disposed of in the morning.
As such, as of now, I don't think I should stand in the way.
Come back on Monday, having obtaining instructions.
Since I have no instructions,
issue. Affidavit of service filed on behalf of the petitioner is taken on. Petitioner participated in the selection process for being appointed as constable
47
in Central Armed Police Forces within brackets CAPFS. Stop. It is submitted by the learned advocate representing the petitioner that on measuring petitioner's height by the concerned authority in terms of the order passed by a coordinate bench on the coordinate bench passed in terms of the order passed by the coordinate bench on 3rd October 2025 on a writ petition being WPA 22433 of 2025. It was found that the height of the petitioner is 169.8 centimeter. Stop. It is submitted that though requisite height is 170 centimeter, but in terms of extent guidelines, petitioner is entitled to get the benefit of rounding off to the next highest centimeter. Since the deficiency of height is less than 0.5 centimeter. Next paragraph. Ms. Alam, learned advocate, is representing Union of India, who is directed to obtain instruction whether petitioner has been adjudged as not qualified solely on the ground of height or for other reasons. Stop. List the matter under the same heading for list the matter under the same heading at the top on
30th. Monday
1st December 2025. 1st December is a combined list day. There is a difficulty. 2nd December.
My lord, only one indulgence. If your lordship kindly takes up page 27 for once, because all the matters are similar. Here, my lord,
come back.
No, because it is stated not qualified in height.
Okay, but anyway, that is the lordship.
Because there is no other reason that has been
Anyway,
mentioned.
let me seek instructions.
27.
Lordship, It's the same order passed.
In the next three matters, my lord.
Lordship, till item number 49, it's the
Where,
same.
where it is stated that is not.
That is the last annexure, Lordship.
Kindly
Not
take, sir,
qualified in height.
page
Lordship.
27.
Page 27.
Oh. Remarks. If your lordship looks into the
Please,
remarks
but-
column, it states that not qualified in height. There is no other reason that has been stated.
It's clear.
Yes, it's clear. Therefore, Lordship,
Issue. Issue. Huh. Affidavit of service filed on behalf of the petitioner is taken on record. Matter is heard in presence of the learned advocates representing the petitioner and Union of India. Stop. On measuring height of the petitioner by the concerned authority, by the concerned respondent authority in terms of the order passed by a coordinate bench on 3rd October 2025 on a writ petition being WPA 22433 of 2025. It was found that height of the petitioner it was found that height of the petitioner is 169.8 centimeter. Stop. It is contended on behalf of the petitioner that since deficiency of height is less than 0.5 centimeter, as requisite height is 170 centimeter, comma, petitioner is entitled to get the benefit of relaxation as contemplated under rule under clause within bracket D of the within bracket D, small d, 2D of the guidelines for recruitment medical examination in Central Armed Police Forces and Assam Rifles of May 2015. Stop. Next paragraph. Ms. Alam, learned advocate, represents Union of India, who has opposed this writ petition. Based on the who has opposed this writ petition, since requisite height for declaring a candidate eligible to be considered for appointment in the post of constable GD is 170 centimeter, where petitioner's height was whereas on measurement petitioner's height was found 169.8 centimeter, which is less than 0.2 centimeter. Stop. Next paragraph. On perusal of clause perusal of relevant part of clause D of revised guidelines, it appears that a relaxation is permitted in the event it is found that the deficiency of height is less than 0.5 centimeter, taking note of the requisite height, that is 70 centimeter. Stop. 70 centimeter. In next paragraph, in the present case, concerned respondent authority measured the height of the petitioner 169.8 centimeter, which is less than 0.2 centimeter. Stop. Therefore, it is found that petitioner is entitled to get the benefit of clause 2D. In clause 2D, wherein provision of relaxation in height is contemplated to the extent of 0.5 centimeter. Stop. Next paragraph. Having considered the submissions made on behalf of the parties and taking note of the relevant provisions as contained in the revised guidelines, concerned respondent authorities are directed to consider the petitioner fit petitioner as an eligible candidate in terms of height, and consider his appointment for the post of constable GD if petitioner is found otherwise eligible.
Otherwise. Because the
Stop.
other-
Aforesaid exercise shall be carried out by the concerned respondent authorities within a period of 4 weeks from the date of communication of this order.
The tests are going on. I believe the
Yes.
examinations are in
Yes.
progress. He'll participate.
Within a period of 4 weeks from the date of communication, or within a period of 6 weeks from the date of communication of this order. Stop.
Malad, 9th is
Now
the
the
last
9th
date.
is
Very well. Let them take stage. If it is by before 6 weeks, then there is no issue. Read petitions as disposed of, or then you accept it. Okay.
Lordship.
170, right.
What
170. Not 70, 170. Yes. Anything more?
No, Lordship, there are the 40, 47, 48, 49.
Same matter.
Same matter, just the height should be noted.
And previously an order was passed by this court.
Yes.
That is, they are relying upon another order. So that part is okay, Lordship. It's not in their matter.
No.
In this matter, I have considered the order passed by the coordinate bench in connection. In the present case also, petitioners moved the coordinate bench on same issue.
Takes up page 32.
Yes. Next,
Item number 47.
He was called in compliance with the order passed on 3rd
page order.
That is, yes, that Lordship, an order was passed in a matter and they have relying upon that. They applied and he was also called.
Yes.
So
Malad, the department, yes,
It's not
department has
his
called
fault.
him.
The department has called him. So that's no. So that way, whatever your lordships have recorded, that is the same. Only the height will change. Where your lordships have mentioned the height, yes, the height will change in each.
No, what I want to know from both of you that in previous matter, petitioner moved a writ petition.
Yes.
And there was a direction to measure the height. Whether that fact is relevant in the present case.
I will point out, my lord, the read numbers are not tallying. The read that has been.
No, that will not tally, but whether the petitioner moved a writ petition previously.
That instructions I will have to take.
No, because lordship, these are orders passed in other writ petitions.
That I find. That's why.
Yes, not moved by the petitioner.
To change
but
for
the authority
other thing is same.
So it doesn't really. It doesn't.
No, if I
matter.
keep that portion, then it will be a defective order.
Because lordship.
My lord, let it be, my lord. Kindly takes it up. My lord, because I will not submit on this because the order that has been annexed. What my instructions
It's
are.
not related
Yes.
to this petition. Even at the one your lordships had directed.
No,
the
no, that is
previous one. Gopal Shikdar.
ওটা তো ওই গোপাল শিকদার আলাদা গোপাল শিকদার হচ্ছে এইটাতে আমি ম্যাডাম একটু বলিনি my lord, here my lord, if your lordship looks into page 32, this is WPA number 22433. In compliance of that order, he was called for remeasurement, but the annexed order is 21866. So my lord, I will not for the time being, my lord, until and unless I get this order and the post title of the writ petition, my lord, I'm not.
Well, not today. You obtain instruction tomorrow.
Yes.
I think that is not fatal because
that is fatal.
I understand, but my lord, I will not.
But what is the proper fact that needs to
Yes,
be?
yes,
Absolutely. Please call the next matter. Next matter is same. Obtain instruction. Come back tomorrow.
49.
Tomorrow.
Till 49, it's the same thing.
Yes.
169.7. This is the height.
Come back tomorrow up to 49.
No.
In all matters, you are appearing for the petitioner 47,
Will it
48,
be
49.
very difficult to fix it day after? অসুবিধা হবে?
আপনার সুবিধা
Day after, day after will be difficult to chip. That is Friday.
Day after tomorrow, very
Day
well.
after. Day after.
Day after tomorrow. Not today and not tomorrow.
Not today, not tomorrow. Deeply.
এই তিনটেকে ওইভাবে নোট করে রাখো যে ডে আফটার টুমরো। Bring this order on the next date, which I have dictated today. You will get it on server by tomorrow.
In other matters also will bring it.
Yes, call item number 50.
Item number 50.
I appeal for the petitioner matter.
I seek to file a supplementary affidavit to place an notification on record, my lord.
Yes, what is the matter about?
Currently, I'm seeking leave to file a notification on record and other prayers, my lord, that the interim prayers as prayed for me in the petitioner, my lord, those are incorrect. That has to be changed. Those have to be changed. If not,
What you have prayed for in the writ petition?
extension of interim.
They'll come back tomorrow.
Not may I come?
My lord, instead of tomorrow, can it be, my lord?
No, all matters cannot be fixed day after. Sorry.
Great.